He's on Zoom.
This is docket 25. I'm
Just
sorry,
waiting for Mr. Mills.
He stepped out earlier on. Right, that book, please. Hi, good morning. So we're the three first, because Mr. Mills just stepped out.
Just string them along. If you want to do them, it's all the same, isn't it?
Are you ready?
We could do all five together.
Sure,
Line everybody
Oh,
across.
sure.
we can add one more defendant to the list. That would be People versus Gerard Young. We're just waiting for Mr. Mills to come into the room and we can go forward on all four of these this morning.
And what about Mr. Forrest?
Madam, my understanding is that Mr.
Yes, ma'am, I'm right here.
Madam, my understanding is that Mr. Forrest is present. His attorney has not appeared this morning, and
I have a note. His attorney called Miss Marble.
Yeah.
Maribel, yeah, she called this morning. She was having stomach issues. I gave on her way down, had to turn around. I gave her the Zoom info. I don't know if she's currently on Zoom yet or not, but I did give her the Zoom info.
well, we can do the other four, Your Honor, and Mrs.
Well,
Maribel is.
And if she's ill, we could do it on a lunch hour or next Wednesday. It's
Next
up to you.
Wednesdays, the defendant's out of custody, we can do it next week.
All right, so let me just, let's
Give
go
me
on the
one second. We're still waiting for Mr. Mills.
Yes.
yeah, but let me
Be
go on the
ready.
record. Mr.
Okay.
Forrest? will you come
You're
forward?
I'm writing this.
I'm gonna call it. Will you come forward, please?
Okay.
Here's Forrest.
So Forrest.
Here's Forrest. And what was your last name? Young.
I just wanted to talk to Mr. Forrest. All right. Nancy, you ready?
I'm ready.
This is docket 25-3250 FC, People of the State of Michigan versus Davion Marquise Forrest. Counsel, your appearances.
All right, thank you. Assistant Prosecutor William Creno on behalf of the people.
My understanding is that your attorney is ill. Please raise your right hand. Do you swear or affirm the testimony you're about to provide with the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
All
ma'am.
right, you may put your hand down. My understanding from my law clerk is that your attorney is ill. I don't prefer that ill attorneys appear on Zoom because I want them to be competent to represent you. So would you mind coming back next Wednesday?
Yes, Your Honor.
All right, so that would be, let me just look at my calendar so I get the date right. Are you working?
No, Your Honor.
Okay, do you have a ride here? How do you drive here?
My mother takes me here.
Is your mother working?
Yes, Your Honor.
Is there a better time for her, morning or afternoon? Do you know? Is she here? Doesn't,
Yes, ma'am.
okay. So, Mr. Creno, that would be February 11th. Is there a better time for you to schedule this?
Your Honor, as the court knows, I'm sort of here and this next couple of weeks. So
right.
February 11th works well, but in the morning, please.
Let's do 10 o'clock, February 11th. I'll need you to be here and having had an opportunity prior to coming on the record to talk with your attorney, and we'll let her know that it's been rescheduled to 10 o'clock on the 11th. And so bond and bond conditions will continue. And if you wish to remain here and watch this, that's certainly fine. It's up to you, but we'll see you on the 11th at 10. So you have personal notice of this, and we're going to give you a written sheet as well as to the time. Do you have any questions?
No, Your Honor.
All right. So you'll work well with your attorney, and if you don't, if there's some kind of breakdown, we'll need to know that as well. But it sounds like you're working well with your attorney.
Yes, Your Honor.
All right, well, illness is going around, so I don't doubt that your attorney's ill, but we're gonna proceed in that fashion. Is that acceptable with the council?
Yes, Your Honor, thank you.
All right, so I will see you February 11th at 10 a.m.
Okay, thank you.
Is that for this one?
I'm sorry.
Is that it for this one?
Yes, that's all for the record. Thank you. We're fine.
Is it young?
I just need to get my,
While the court reporter prepares, I have 4 files. What I would like all of you to do, and you'll need to keep your voices up, but I do have a lot of microphones. But as I call you, line up here, so I will try to address you in the order that I call you. And we'll keep the record straight, but that way it appears from what I understand, this is really going to be the same for all of you, so it will save us all time. If there's anyone who objects and wants to do this separately, that is fine with me. When you're ready, Nancy.
let's go.
All right, this is docket 25-3247 FC, People of the State of Michigan versus Gerard Young. Counsel, your appearance for the record.
May it please the court, David B. Carter Jr. on behalf of Gerard Young, who is present standing at the podium.
All right, and if you could stand next to counsel. Maybe to the right of you. Yeah, all right. And this is docket 25-3246 FC, People of the State of Michigan versus Anthony White Jr. Counsel, your appearance for the record.
Lisa James on behalf of Anthony White Jr., who is standing at the podium to my right.
Thank you. And this is docket 25-3251 FC, People of the State of Michigan versus Tashara Monique Lynch.
Good morning, Your Honor. Ronald Woolley on behalf of Mr. Cheryl Lynch. She is standing to my right.
Thank you. And finally, we have docket 25-3248 FC, People of the State of Michigan versus Dejan Lenore. Counsel, your appearances.
Yes, and good morning, Your Honor. Stephen Milks on behalf of Mr. Lenore. Mr. Lenore present, staying to my right.
All right. Mr. Young, Mr. White, Mr. Lynch, or Ms. Lynch, and Mr. Lenore, please raise your right hands. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Mr. Young,
Yes, ma'am.
Mr. White,
Yes, ma'am.
Ms. Lynch,
Yes, Your Honor.
Mr. Lenore,
Ma'am.
will you each put your hands down? Have any of you taken any medication, used marijuana or alcohol, anything at all yesterday or today? Mr. Young,
No, ma'am.
Mr. White,
No, ma'am.
Ms. Lynch,
No, Your Honor.
Mr. Lenore.
No, ma'am.
Is there medication you're supposed to be on that you're not on, Mr. Young?
I got some toothache medicine from my from the doctor from like 2 days ago. I forgot. You gotta ask my mom what it is. I don't know what it is.
I don't know, I don't need to know what it is, but you not taking that, are you in enough pain where you're not going to be able to concentrate or understand what's happening today?
No, I'm good today, cause I took my medicine.
Okay, and counsel, you believe he's oriented to date, time, and place, and does understand what's occurring?
Yes.
All right, and Mr. White, anything you're supposed to be on that you're not on?
No, ma'am.
And Ms. Lynch, anything you're supposed to be on?
No, Your Honor.
And Mr. Lenore,
No, no.
any of you have any sign of fever, COVID, or other illness that would make it difficult for you to understand or be here today? Mr. Young,
No, ma'am.
Mr. White,
No, ma'am.
Ms. Lynch,
No, Your Honor.
Mr. Lenore.
No, ma'am.
Have you all had enough time to speak with your attorneys in regard to the final pretrial? Mr. Young,
Yes, ma'am.
Mr. White,
Yes, ma'am.
Ms. Lynch,
Yes, Your Honor.
Mr. Lenore.
Yes, ma'am.
This is a final pretrial, and it's not meant to pressure you or force you to do anything. However, what it is meant to do is to have a cutoff, because I do not allow a plea on the day of trial, because if I do that, then I would be denying somebody else that place on my docket to have a trial. And all of us judges, we're a judge short in this county, the studies have shown that. And so we need to keep cases moving. And the only way I can do that is to have cutoffs. And it looks to me like you've all had enough time to make these considerations. If you haven't, please let me know. But I understand there've been discussions and we're going to hear from the people. I don't want you to make a decision where you've been forced, coerced, threatened, but we do have to have this cutoff. So hopefully there's been enough time for you to meet with your attorney, consider whatever the options are. And I don't know, I haven't even read a police report because they don't give me police reports. And so unless there's an extenuating circumstance and it's needed. So I don't know anything about your case, but I do set these final pre-trials to keep things moving. That is to protect your rights to a speedy trial as well as any victim. Do you understand that, Mr. Young?
Yes, ma'am.
Mr. White?
Yes, ma'am.
Ms. Lynch?
Yes, Your Honor.
Mr. Lenore?
Yes, ma'am.
All right. Has there been an offer on behalf of the people in this case? And I don't know if it's the same for everyone or different, but if you could indicate what, if any, offer, and if they're the same, and if it's the same on each trial, or if there's any differences on behalf of the people.
Your Honor, thank you. Assistant Prosecutor William Creno on behalf of the people of the state of Michigan. The short answer to the court's question is an offer has not been extended to any of the defendants in this case for the following reasons, Your Honor. First of all, I've had an opportunity to speak to all counsel in relationship to this matter multiple times prior to the final pretrial conference. There are a number of issues that need to be addressed before the court before we can get to the point in time of making any final discussions for plea negotiations or whether there will be trials in this case. The first and primary issue is this, Your Honor. The nature of the charges of this case are as follows. First of all, the defendants are each charged respectively with count 1, open murder, count 2, assault with intent to murder, count 3, discharge from a vehicle causing death, count 4, carrying concealed weapon, and counts 5, 6, and 7, felony firearm. This is a very complex case based upon the nature of the facts, as well as the number of co-defendants that are involved in this case. There was an over 2 full days of preliminary examination testimony in the 54A district court. Understanding the complexity of the case, Your Honor, it is the people's intention, first of all, to make a final decision as to joinder of defendant. I think that the preliminary examination was held with 5 co-defendants. That was extremely unruly with 5 co-defendants, and all the testimony we had, it was a security concern. Primarily, there was tremendous complexity, and it just was untenable, at least from the people's perspective. So what our intentions are as follows. We intend to file a motion to join these in groups of 3 and 2. The first trial that we intend to join would be People versus Dejan Lenore, People versus Tashara Lynch, and People versus Anthony White Jr. So we will be filing a motion to consolidate those 3 for a single jury trial. And then we will be filing a motion to consolidate the other 2 individuals, the remaining 2 individuals, for a separate jury trial. So we will need 2 jury trial dates in this case. I'm not sure what the position of the defense attorneys will be. I've heard different things from different defense attorneys about whether they will oppose joinder, whether they will consent to joinder, but that's the first issue that has to be taken care of. As the court knows, the people are actively involved in a long case this month, so we did not have the time to file that motion practice. We will need the time to do that. The second issue, Your Honor, is that there is a major discovery issue that is currently pending. It's not something that is difficult to resolve, but there are 2 pieces of evidence that the people are in possession of, that we have advised the defense we are in possession of, and for security and other reasons, we have not yet turned those pieces over. Our intention will be to do so in the month of March. Those will be critical pieces of evidence that the defense needs to review in this case, Your Honor, before any decisions can be made. And lastly, The preliminary examination has not been provided to us yet, and there's no way that council can go to trial in a case like this without the detailed preliminary examination transcript, which we don't have.
Can I ask you when that was? Obviously, we all know this is a problem and we are working with the chief judge and the district courts to resolve this. So I like to keep track of that. Do you know when it was approximately requested? Because if it's been too long, I need to alert the chief judge and we need to prompt them, so to speak.
The preliminary examination transcript was requested by all parties at the time of the bind over. So I think that was June of last year. I know Mr. Milks has made a separate request recently for the transcript, and I received an email that said, you still want us to do it? And the answer is, of course, we still need you to do it. This is a case that requires preliminary examination transcript for motion practice, for testimony, for otherwise. So the reason I give that history to the court, Your Honor, and this would also apply to Mr. Forrest's case, and he's going to have this continued pre-trial next week. We're not even close to the point in time where we are ready to go to trial or make final offers. We're all working diligently to do that. I think there was a tentative trial date for March 13th. That is
That
not
will
a
be
date.
moved.
That's going to be moved. There's something else on that day. We'd like to work together with counsel once these issues are resolved to set a final trial date. We can't be a backup. This is going to be a 2 to 3 week trial, and there will be multiple of them. So that's where the case is today, Your Honor. I'll defer to counsel to kind of address all of these issues. In terms of the other discovery, everything is up to date. There are 2 major issues that we are intending to disclose. We will just do that within the month. Thank you.
So before I turn to defense counsel, I know it's a lot of work. I'm not ignorant to the fact of what happens to trial attorneys and how busy you are. I was a trial attorney, so I don't know if I'm granting joinder or not, but are you looking at doing these back to back or a few months apart or weeks apart? How are you anticipating?
The 2 respective trials,
Yes.
Your Honor, assuming that joinder, I just want to say this, it's entirely conceivable that you're going to deny joinder. So I don't know. If that's the case, then we're doing conceivably 5 trials.
And did you want them back to back or weeks apart? I'm just looking at my docket because I'd like to get these in by the end of the year, and perhaps we could use November, December as your months.
Yeah, I don't think we even need it out that far. I think into the midsummer or late spring or early summer would be my intention to start the cases. I think I need to get with counsel. I know we have all 5 busy counsel, try to get dates that work, and maybe we can get back with the court. I don't know if we're gonna be able to
Well,
resolve that.
July
today.
is out. I'm going to take some time off in July, as does most of Michiganders, because it's the only month we have that's really great. So July is out. I don't know about the rest, but I know with all of your busy schedules, the fallback for me would be November, December. But obviously I have time hopefully before then, but my docket, and we've got some older cases that must be tried. So I don't know if there's gonna be 2 trials or 5. I leave that reserved, but if we can, even if we do 1 in June and 1 in August and 1 in September and 1 in November, December, because I know that's a lot of work. So I leave that up to all of you, and we need to work that out. And as you know, I am doing these types of cases on my civil docket because they never go, and that will not disrupt the criminal docket. It doesn't affect my regular docket attorney, so he can still prepare on those off weeks. So I'm happy to work with you on that, and so is my staff. So I will grant you that, but I need to set a final pretrial that you think is reasonable, because it will not leave without a date.
For final pre-trial, Your Honor?
Yes, sir. I can't leave this without a date. Then people get lost, and then things get scheduled, and then things get pushed out, and it's not fair. So
If I may interject, instead of a final pretrial, because there's a lot of work to be done yet, I would ask the court to set another control date in June. And obviously that's not for us to pick trial dates in June. We can do that in the meantime, but at least do a control, perhaps a status conference in June.
everybody in agreement with that, or would you like it earlier or later?
We would like a status conference either in mid-May or June would work for the people.
Great, May 13th at 1 o'clock. Unless you like it in the morning.
Well, May 13th at 1 o'clock works well for the people and that would be for a status conference, Your Honor?
Yes.
Thank you, that's perfect.
I will be in a homicide trial in Jackson.
Do they run on Wednesdays?
Yes.
Okay, how about May 20th? Or May 6th?
May 20th will work.
Great, May 20th. Does that work for everybody else?
Yes,
That
do
work?
1 o'clock.
Okay, so we'll do a status on all 5. And if we need to move it, because the other attorney's not here, we can move it back or forward a week or 2, but let's keep this going. All right,
Is the court going to require that we be in person, or would Zoom be appropriate there? Unless it's some sort of plea, just being a status conference like that. It might be easier for some of the defendants. I know my client would rather have him be brought over. I don't know if that'd be easier for the court or for the parties here.
well, I think the client should be brought over and you all should be in person. This is a capital case. I'd rather you be in person because there's always things, especially if there's going to be a status conference and perhaps an offer made, you can talk with your client. I'm usually not opposed to Zoom, but on this, let's keep it moving in person. Are you available in person?
Yes, Your Honor, that's fine.
Great. And I will contact, when did you request that preliminary exam transcript or check in on it last?
Yeah, that was someone from my staff. I don't have that right in front of me right now, but
But it's been pending since June of 2025?
yes, Your Honor, I know, just as Mr. Crino already said, we've all requested it, we all signed the document for it. It is over 2 days. We've seen how long it takes with.
Yeah,
One
not
day.
acceptable. What I'm, do you have, if one of you or all of you, I don't care, I really just need one, if you could send me a copy of that so I can put it in the hands of the chief judge. It's unconscionable what the district court's doing to us, so.
They don't give us copies when we
Yeah,
ask.
But that, if I may, Your Honor, Lionel William, on behalf of Ms. Lynch, as Mr. Crino stated, at the end of the second day of the preliminary examination, I know that myself, particular, did sign the form and requested the preliminary examination back then. And I believe every attorney that would be on this panel would have done the same. So it's
Do
been
you have a
pending.
copy of that?
I don't have a copy of the form that we signed, but as Mr. Crino stated, there was an email that did go around a couple of weeks ago
Okay.
or a few weeks ago asking if we still needed that.
Would you mind forwarding that to me, and from now on, until we get this resolved between the courts? Because I know the chief judge is actively engaged with the other chief judges, and this is not acceptable. Take a snapshot of that request and send it to us so we know, because it's happening and it's delaying cases and it's interfering with your ability to timely prepare, which is not acceptable. So let me know.
I will send it, Your Honor.
Okay. Any objection, whether I receive it from one or all of you? All right, and I'm gonna forward that. That's just unacceptable. Anything else I can do?
Rather, nothing for the people. I think that's a good resolution here this morning. I think that will give us time to take care of the outstanding discovery issues. We can get our motions filed within that time frame, and we should be in a much better position to set a firm final pretrial and trial date when we reconvene at the status conference in May.
All right, so bond and bond conditions will continue, and yes.
I do have a request on bond. My client is under house arrest. He would like to be employed. Is the court open to allowing my client to be employed while on tether?
Counsel?
In order to address that, we would request a formal, on a case of the severity of this nature, when it's our position that these defendants are out on bonds that are way too low, and a very serious event occurred here, a very violent event occurred here, we would oppose that without any type of written motion being filed.
And I didn't set the bond, so I don't know, district court did. Or why don't you just ask them for a bond report and request a hearing in front of me? And I'll make my decision then.
Thank you.
For any
Thank
of you. And your client's the only one incarcerated?
He is, Your Honor. He's also being held on more than just one.
He's also what?
Being held on more than one case.
Okay, all right, so, sir, you're getting what you need at the jail? Okay. Is there anything else we need to address for today?
Nothing for the people.
Nothing.
Of the pending minutes.
None from Ms. Lynch, Your Honor.
Nothing for Mr. Lenore.
All right, thank you.
Thank you.
That's all for the record.
There's also. She's a recorder, and she'll hire people to get the transcript out of that recorder wrong.
Yes.
Okay. So I'm gonna talk to, I need all five.
I'll get back to you later on, I'm sorry.
Exactly.
We can do Johnny Greenwood next.
Okay. Just give me this one.
We were gonna handle that after.
Okay.
I just.
Johnny Greenwood.
What time is this one for?
At 9 o'clock. Should be,
It's
it's
the
the third one,
sixth one down.
or 6 will be down after the.
I don't have it on mine.
No.
You should.
I don't. Is it Greenwood, one word?
Yep. Johnny Greenwood, the third.
Johnny.
Oh, it's here. Hold on.
Oh, you got it?
Just another page.
Yes, there we go.
I'm good now. I'm sorry. I'm like, where's my other page? It was on Monday. Right, everybody got this. It's the original now.
All right. This is docket 24825 FH, people of the state of Michigan versus Tyshawn Marquise. Is it Falante?
No, Johnny Greenwood, you're on.
Greenwood, Your Honor.
Greenwood. That's what I have as the whole name. Is this the right?
Johnny Greenwood?
No, this is, they gave me the wrong Greenwood. Okay. We have apparently another Greenwood. Sorry, sir. Let me get the real file. Walk the record a moment. So this is docket 256041 FH, people of the state of Michigan versus Johnny Greenwood III. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Luxon on behalf of the people of the state of Michigan.
Good morning, Your Honor. Toby White, I'm here on behalf of Johnny Greenwood.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. You may put your hand down. You'll need to keep your voice up. Counsel, please move the microphone closer to him. All right. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with Mr. White?
Yes, ma'am.
All right, and this is a final criminal pretrial conference, and this is meant to keep your case moving forward. At some point, you have to make a decision. I do not allow, please, on the date of the trial, and many people say, oh my gosh, it's happening, and then they change their mind. So I have to have a cutoff because we're then giving up time for somebody else who could have had a trial. So that's why you have this. So, sir, you've talked about your, whatever it is you wanted to talk about with Mr. White.
Yes, ma'am.
All right. And on behalf of the people, what is the offer?
Well, Your Honor, I guess before I go into the offer, I will say that Attorney White is new to the case. I've not even received a paperwork transferring the case to him from
I
Attorney
just signed
Kaplan.
it. I just signed it. Mr. White, let me ask you, are you ready?
Let me not answer this yes or no, let me explain what's going on.
Okay.
We found out that this is a final pretrial, and we understand, I talked to Jeffrey, he said it's set for mid-March as a trial date.
Okay.
We do have to file a motion, we would like.
We could potentially move this to April 17th. That would work for Attorney White.
That will work.
All right, so I'm going to move the trial to April 17th.
Before I leave, Your Honor, I'll go back and get a motion date.
My judicial assistant is ill. May I give you a motion?
Sure.
Like that in March?
That's fine.
How about March 18th at 11 o'clock? And then if that doesn't work for you, you can call her and change it. But I like to get things on the book so that it doesn't get over congested and everybody has a date and we don't lose track of things.
Do we want to set that for a final pretrial on the same day, just so they're both there?
Yeah, that would be fine.
All right, so it'll be a motion and final pretrial.
Okay, March 18th is bad. Can we do the next week, 25th?
Sure. March 25th at 11. Everybody needs to change it pretty well. Sir, does that give you enough time to work with your attorney?
Yes, ma'am.
All right. And then I don't know what the motion is, haven't seen it, can't predetermine anything, but if for some reason you need some more time on the final pretrial, I'm willing to move it another week or two, but not, let's work within the confines of the trial date.
That's fine. So I think that the timeline we've just carved out will work just fine. Like I said, it's not gonna head to a trial. We'll take a look at these issues and resolve the case.
Bond and bond conditions are continued, and if you do change your mind, want to go to trial, we can go to trial, and I'm not holding counsels back, 'cause you never know what happens, okay?
Yes, ma'am.
All right, any bond condition you can't comply with?
No, ma'am.
All right, I'll see you then in March.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah.
Your Honor, can we approach?
Yes.
It's just.
I don't know.
Adrian Davis. It's not, it was, you just signed a bench order right yesterday. It was set. It looks like you said it for, they were set for a final pretrial April 29th. So it's the next 10 days of hearing. It is 25-00513 LC. 5183 LC.
All right, you,
Did you find it?
let me know when you're ready, Nancy.
Is this one on it?
I know,
Okay,
it's just a bench warrant that we're dealing with.
okay.
And then I want to deal with versus and Martha. This is people of the state of Michigan versus Adrian Davis. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of people of the state of Michigan.
Good morning, Your Honor. Toby White on behalf of Adrian Davis. He is at the podium with me.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury? Let me put your hand down. I understand I signed a bench warrant because it was alleged that you failed to report to pretrial services. You have a file that is pending. There's a final pretrial scheduled for April 29th, 2026. You've appeared here today. Your attorneys have explained to me that you did attempt to call and no one answered. So here's the deal. I'm going to recall and dismiss the bench warrant. If that happens again, please call your attorney and he'll let me know and we'll deal with pretrial services ourselves because they need to respond to you and just document the phone calls you've made, let your attorney know. They have my cell phone. They can call me 24/7 so that this doesn't happen again. Can you do that?
Yes, ma'am.
All right. Anything else we need to know?
I guess my only question, Your Honor, is if the defendant has made contact since this November date, because it looks as though per the memorandum given to Your Honor, the last time that there was a telephone check-in was December 9th of 2025.
All right, well, there's all sorts of, everybody's shorthanded downstairs. I get these complaints all the time. So counsel, please, I don't care, sir, put your phone down. Sir, no, don't, I'm not wasting more time on this. Here's what I want you to do, counsel. Direct him to go downstairs, check in with
I will.
pretrial services, make and keep an appointment. If there's any other issues, have him call you or your staff, and let's get to the bottom of this. Thank you for showing up today. Anything else?
No, that'll do
Bond
it.
and bond conditions are continued. Thank you.
Thank you, Your Honor.
Aubrey Ophis next.
Yes, please.
Never signed it before.
I said I signed it yesterday, but I don't know.
You signed the order. I don't know. Because I don't have to make a recall, but you never signed it.
Yes.
Recall it.
It's not. I don't know.
If I see it, I just won't file it.
That's fine.
Okay.
So you're gonna just, you'll take care of whatever.
Yeah.
Great. Deputy, would you approach for a moment? Return it. It's yours. Yeah. So. This is docket 2481FH, People of the State of Michigan versus Otis Latrice Aubrey. Counsel, your appearance for the record.
Good morning, Your Honor. EP Bart Books on behalf of People State of Michigan.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Aubrey. Mr. Aubrey appearing via Zoom at this time. He's currently in MUSC.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Okay, you are muted. Brian, can we unmute him?
Oh, I think it's on.
He's got unmuted.
Sir, can you unmute? Is there an unmute button where you are, or can somebody there assist you? I can't hear you.
Maybe I don't know, he can go grab somebody.
Can you get up and ask someone? I just need them to unmute you. Thank you. All right. Can you hear me now? Can you say something? All right. You swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. Thank you. Put your hand down. Have you taken any medication yesterday or today?
Just my psych meds, Your Honor.
Yeah, that's good. And so have they been helping you?
Yes, Your Honor, they have.
All right. So today's a good day for you?
Yes, it is, Your Honor.
Is there any medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
And you've had enough time to speak with your attorney?
Yes, Your Honor.
All right, and sir, this is a final criminal pretrial. And that is so that we can keep the case moving and a decision has to be made. Because I don't allow people to plead generally on the day of a jury trial, because then you'd be denying somebody else their day in trial. Do you understand that?
Yes, Your Honor.
All right, has there been an offer made?
There has been, Your Honor.
And what is the offer?
The offer would be to plead to an added count 2, fleeing 4th degree upon successful, and that is a two-year felony. And upon successful plea and sentencing, the count 1, fleeing 3rd, which is a felony that is punishable up to 5 years, would be dismissed. And the habitual 4th offender status would be amended to a habitual 2nd offender status. It is my understanding that Mr. Aubrey does not wish to accept that plea offer at this point and wishes to move forward with trial.
And just to be clear, the habitual, the fleeing 4th, would that be under the penal code?
That would be under the penal code, yes, Your Honor.
Okay. Counsel, is that full, fair, accurate, and complete?
Yes, Your Honor, that is full, fair, accurate, and complete. I did the opportunity to speak with Mr. Aubrey. We went over his rights regarding potential trial strategies. I believe he is aware, I believe he's oriented, and I believe he is rational in his decision-making, but he does wish to refuse the plea offer and go forward with trial.
All right, and so just to be clear, with the habitual 2nd, that 2-year would be a 3-year.
Correct, Your Honor. And if he were to go to trial and be found guilty, then the habitual 4th would make the fleeing 3rd a life offense. As it is 5 or more.
You mean the fleeing 4th? The habitual 4th.
The habitual 4th would make the fleeing 3rd, yes, a life offense, Your Honor.
Okay, and have guideline discussions been part of this to make him aware of the potentials or not?
They have, Your Honor. We which would have been a little bit while ago, regarding our last discussion regarding, potential outcomes here. I think it was before we had the offer though. My client has been straightforward with not accepting a plea deal in this matter and wanting to go to trial. Always been my understanding in this case.
All right. And does he have a potential outdate of his current incarceration?
What I see, Your Honor, I have the website pulled up. It looks as if his earliest release date would be October 3rd of 2026.
Is this charge holding him in there?
That I am not certain. I believe I am not certain about that, Your Honor. I know that when he was originally out, there was this case that was holding him. He was released on a 25,000 PR bond in this case. Calhoun County, which sentenced him here, is what and landed him in MDOC custody currently. So yeah, no, this case is not holding.
Yes, it looks like it's ultimately the Calhoun County sentence.
I'm
that
sorry,
has-
can you repeat that?
It does look like the Calhoun County sentence is the one that has him in DOC currently.
Okay. Now that's all full, fair, accurate, and complete, some of the background and the offer, is that correct?
That is my understanding, yes, Your Honor.
All right, Mr. Aubrey, you've heard all of that. Would you agree that's full, fair, accurate, and complete?
I feel like I didn't have enough time to talk to my attorney about the guidelines, but it is accurate, yeah.
Okay. Would you like some more time now to talk to your attorney about the guidelines?
Yes, Your Honor.
Great, we're gonna make that happen, okay?
Yes, Your Honor.
Okay, because it's important because with habitual, force, this would be punishable by for life. I have no idea what I would do. This isn't probably something I would sentence you to life on. However, I don't know where the guidelines are, which is important along with your history, which I also don't know. But under the plea agreement, that habitual second changes it to a potential 3-year. And so that is an important consideration. So I'm gonna give you that time to talk with your attorney and you'll let me know when you're ready this morning, okay? And counsel, if you need
Yes,
more
Your
time for some legitimate reason, let me know.
Very good, Your Honor. Thank you
We'll
very
put you
much.
in the back room and, all right,
Thank you so much.
we'll put you in a breakout room, thank you.
Johnny Pete?
Mr. Pete Marcano?
All right, this is docket 256003 FH. People of the state of Michigan versus Johnny Ray Pete. Counsel, your appearance for the record.
Good morning, Your Honor. APA Burt Luxon on behalf of the people of the state of Michigan.
Aaron Robinson, Assistant Public Defender for Mr. Pete.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, maybe put your hand down. Sir, you pled guilty to police officer assaulting, resisting, obstructing with habitual second. That is punishable by up to 3 years. Do you recall that?
Yes, Your Honor.
I could find that in your Apple Music library. You can ask me to play a radio station or ask for your music on a different app.
Siri somehow decided to intervene in our conversation, I suppose. Siri in contempt.
It's when you say sir on.
Yep, does it every
The
time.
keyword is sir on. Every time you say sir on.
Well, he needs to understand language. I don't know. AI is just not very good, is it? I also have it on silent, so I don't know why he's not been silent. But anyway. Sir, have you taken any medication yesterday or today?
What?
Have you taken any medication yesterday or today?
Oh, yes, Your Honor. That's what I want to tell you.
I'm on,
You don't need to tell me what you're on, but you're taking medication?
oh, yes.
Okay, does it affect your ability to understand the court or your attorney?
I go 3 times a month.
Okay,
Yeah,
and so are you doing well on it?
yes, Your Honor.
And so are you able to understand your attorney in the court?
Yes. I'm making, more better decisions now.
That's good.
Yeah.
Good to hear. Okay.
Yeah.
So is there medication or other treatment that you're supposed to be on that you're not on?
Yeah, my brother and his wife are my caregivers now.
Okay.
For, CMH. They just got it, all on paper now.
Are they here with you today?
Yeah.
Okay, where are they?
My brother was here. I think he took off for a minute.
Okay, okay. Now, do you have any sign of fever, COVID, or other illness?
Yes.
No, do you have, she's asking if you have COVID. You say, do you have any signs of COVID or fever, or are you sick?
Oh, yeah.
Are you sick or not?
Oh, no.
Okay, sure.
I thought she was talking about something
That's
about
okay.
my
It's
medicine.
okay. Yeah, it's okay. Now, do you have any trouble hearing? We can get you help.
Yeah, I can use that.
That'd be great. Breakout room.
Here already.
That's loud.
Thank you.
Better, sir?
Yes,
All right, good. And if you could put them in a breakout room.
Who? Yeah, Milks.
All right. So, sir, you pled guilty to police officer assaulting, resisting, obstructing because of the habitual stagnant punishable by 3 years. You recall that?
Yes.
All right. And have you had an opportunity to review and read the pre-sentence investigation report?
A little bit of it.
Or do you need to go over it more with your attorney?
No.
Okay, but you did have an opportunity to discuss it with Ms. Robinson,
Yes.
and you discussed whatever it is you wanted to talk about with her about sentencing, right?
Yes, Your Honor.
Are you ready to move forward today?
Yes.
Okay. And on behalf of the people, are there any corrections, additions, deletions?
The only one, Your Honor, is on page 1 of the evaluation plan. In the first paragraph, it says that the Honorable James Jamo is the judge on this case, and obviously he is not, so.
Yes, this must have been one that was transferred from him to me under our big transfer at the end of last year, so I'm changing it to me.
And that is the only change that I saw, Your Honor.
And it does have me on the cover page.
Correct.
So maybe they just did a typo over and forgot that. All right. And it does have that in the.
It's correct everywhere else I
Yeah,
can
on the
see.
guideline sheet, yeah. Any corrections, additions, deletions on behalf of defendant?
No, Your Honor.
And as to the guidelines?
No changes to the guidelines, Your Honor.
On behalf of the people, what is the recommendation or what would you like me to know?
Yes, Your Honor, I would ask that you follow the recommendation given by probation in this matter. I do believe that Swift and Sure would be appropriate.
And I will never use Swift and Sure, so you can recommend it all day long, but that won't be something I do. I take care of my own people.
Understood, Your Honor. Then I would ask that you continue the defendant with community mental health and taking his medication. As he stated, it seems to be helping him a lot. I would also ask there be some kind of substance abuse treatment for both marijuana and alcohol, as he seems to have been under the influence of both during this incident. And I would ask for a probationary period of 24 months. Thank you, Your Honor.
Thank you. And was there a victim, was any victim contacted, or all victims? I don't know who exactly was the victim. It looks like law enforcement and perhaps Some other
It
individual.
was just law enforcement, Your Honor.
Okay. Counsel, what would you like?
Yes, Your Honor, we'd ask that you follow the recommendation of 24 months of probation, however, without the split insure. As Mr. Pete stated, he is working with community mental health. He does have family support that's on board with him. He's not currently working at this time because he does receive disability. He's working to kind of get his life back on track. I don't believe he's a danger to the society in any way, and I think he would benefit from the court's oversight as well as the programming offered by probation.
So the family members, did they go to probate? Did they have guardianship of him or what?
No,
did
they went to my meeting last week,
Okay.
last Tuesday at CMS.
That's fine.
And like I said, they're now my caregivers.
Okay. So I don't know your status, sir. I don't know all the ins and outs about what you're going through, but at some point you might want to all go to probate court so that they can have a legal guardianship over you to help you manage your money, to have access to medical and do other things for you to help you out, so that for the long term, you're taken care of and no one's defrauding you and all of that, because we see sort of a cycle of events that happens.
Yeah.
And it sounds to me, to your credit, you are accepting help, and that's another way for the long term in your life to continue to get help if they're willing to do that.
Okay.
So, counsel, you might want to have a conversation with them, you know how it goes. I think that sometimes that works out really well, because when you no longer choose or have to work with community mental health, that may go away, and then a cycle starts again. So if they just remain involved with you, as long as you trust them and you're all working well together, which it sounds like that might be in your best interest, so just consider it.
Yeah.
Okay, I'm not gonna order it, but it sounds like this might be a very good case for it, and I applaud you for cooperating with that.
Okay, thank you.
Okay, and you're doing okay on your meds?
Oh, yes, ma'am.
All right, you feeling better?
Oh, yes, ma'am.
Okay. Sir, since you've already been proactive and have taken some steps, I'm going to put you on 18 months probation. You at least have to do half of that. If you are not doing well, then I can increase it up to 36 months, and then I can increase it up to 5 years. I could incarcerate you, but it doesn't sound like I need to do that. You are going to complete sexual abuse prevention programming and any other treatment that's recommended by probation and community mental health. You'll sign all necessary releases so we can verify that you're doing what you need to do. He did not. Well, I guess he is he's already a registered, he's already complying with, that's under separate orders.
Correct.
So he'll comply with the Michigan Sex Offenders Registration Act as previously ordered, in terms of just following the law. It's not applicable under this file except to say that follow the law. You will not use, possess, consume, purchase, or be in the presence of alcohol, or illegal drugs, or drug paraphernalia. If you have the need for any of those things, you will present a prescription from a licensed medical physician within 24 hours. You can take over-the-counter medications as labeled on the bottle. You can take less but not more, and all prescribed medications you'll take as prescribed. You will take all psychotropic medications as labeled on the bottle. Sometimes people take them and say it's not working or I don't like them. If that's the case, you work with your doctors to change them before you just stop taking them, because otherwise you end up in trouble. You understand that?
Yes, ma'am.
All right, and there's a lot of different options. So if they begin to make you feel awful or what have you, then, or don't let you sleep or whatever, you just work with them. Don't just stop it. Do you understand? Okay. So you'll follow all doctor's recommendations, sign releases. You will attend AA, NA, and or CA meetings if recommended or when recommended by CMH. They may have some other programming that's in its place. I don't know.
I go to the Abbott House to the substance abuse program.
Okay, so you'll continue to go to the Abbott House and follow all recommendations there. You're liking that?
Yes.
All right.
In other words, I volunteered my time.
Okay,
Yes,
That's a good program, so
Yeah.
that's a very good thing for you to do, so I'm just gonna order that you continue to do that. You will complete all recommended treatment, sign necessary releases, you'll not change your residence unless you first obtain written permission from probation. You will not have verbal, written, electronic, or physical contact with anyone known to be a member of a gang, and you will not be involved in gang-related activities, wear gang colors or insignia or tattoos. You'll obey all court orders and recommendations from all treatment providers, including probation, all of that becomes orders of this court. You will possess a valid driver's license or state of Michigan personal identification card issued by the Michigan Secretary of State and keep it on your person at all times. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have any verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections who is a felon, who's on probation or parole. If you need to have contact with those persons, then as long as they are in good standing and you receive permission, that's fine. Now, you do not have to ask everybody you meet if they're on probation or parole, but if you find that that's happening and they're part of your group or what have you, just let us know, okay? You will not use any object as a weapon. You will not own, use, or have under control or area of control a weapon or imitation of a weapon of any kind. No guns, no knives, no ammunition. You will not be in the presence of anyone who has those items, and you'll not use any object as a weapon. You'll contact probation today
yes, yeah,
and make and keep all appointments. Your attorney can direct you down to probation so that you can make and keep that appointment. If you need to change any appointment, that's on you. You chase them, they don't chase you. And if there's ever a problem reaching them, let the court know, let your attorney know so we can help you so you don't end up in a bench court status.
me and my agent are on the same page right now.
Good, good. Well, let's keep it that way. But if there's ever a problem, let us know so we can help you before it becomes a problem. Okay?
Yeah.
We'll allow probation into residence at any time for probation supervision without a warrant and submit to a search of your person and property, including but not limited to vehicle, cell phone, residence, and computer. If there's reasonable cause to believe you have items that might violate the conditions of your probation, you must report any arrest or police contact, personal protection order placed on you, loss of employment. If you choose to work, it would be within the regulations of SSI. I understand you're on that. You'll advise us of any change of residence within 24 hours. Weekends and holidays are accepted. All phones need to be off or they will be confiscated. Is that your tether?
Oh, I think that's his tether.
Oh,
Yes.
no, that's my phone.
Oh, your phone?
Got to turn it off, sir.
I'm sorry. Scam calling.
All right. You will serve 365 days jail with credit for 26 days served. The balance is held. I can use any or all of that time while on probation. You'll pay crime victims assessment amount of $130 and a $68 cost, state cost. So that's $198. That will be due February 14th of 20.
That's my present?
2030, yeah. You got a long time to pay. So return pop bottles if you need to. That's plenty of time to pay a couple dollars a month. I know that you're on SSI and you've got a lot of issues, so I've given you a long time to pay so they don't assess you.
Yeah.
Late fees and all of that, but don't forget about it. You owe $198, get it paid as soon as you can. There'll be no probation oversight fees. I'm finding he's indigent. There'll be no attorney fees. I'm finding he's indigent. No court costs. He's indigent. If you end up using marijuana or alcohol, it would only be as prescribed, if prescribed. You will continue to work with community mental health and any other agencies you're working with, keep all scheduled appointments and follow all recommendations. Is there anything else I have failed to address?
Nothing for defense, Judge.
Nothing with people, Your Honor, thank you.
Sir, is there anything I told you to do that you think you can't do?
Oh, no, yeah.
All right. Good luck to you. You have 42 days to appeal to request appellate counsel. Please hand in his appellate rights.
Thank you.
It was 365 with credit for 26 days. And the balance is held. All right, so don't go downstairs now and make your appointment. To acknowledge receiving your health rights.
Yeah.
So if you don't like this, or if there's a problem, you use that, okay? I 42 days. Good luck to you, son.
Thank you.
You Timothy Pitcher next. It's not on the document. I think it's case number 40.
Yes. This is docket 25-241 FH, People State of Michigan versus Timothy Lee Pitcher. Counsel, your appearance for the record.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Pitcher. Mr. Pitcher present, stands to my right.
Good morning, Your Honor. Jacob Sarge IV, stepping in for Dwayne Silverthorne, acting as the senior supervising counsel for IDC purposes for today's proceedings. Thank you.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. And counsel, what are we doing here today?
Your Honor, today was initially the day scheduled for a plea. When we were last here, Mr. Pitcher was on Zoom with MDOC and the connection made it untenable. Sorry, the last time Mr. Pitcher was here. Then there was an issue with the writ the last time we were here. And so we immediately got that writ done. I think you remember while we were still in the courtroom to make sure there wouldn't be issues again, we could get him here for the plea. It is now my understanding that he does not want to take the plea and he wants to represent himself at trial. And so
okay,
once we go through all those questions, I will then place the offer and guidelines.
Okay, where is he on the docket?
He isn't.
He's not. For whatever reason, it did not go onto the docket, so this court absolutely set it for this date and time.
Yes.
Okay. All right, sir, I understand you do not want to be represented by counsel, you are choosing to represent yourself. And has there been a breakdown in the attorney-client relationship?
Yes, ma'am.
Okay, so let me ask you this, if you're ready to represent yourself, but you're not a lawyer, I don't think it's wise, but it is your right. You have count 1 unarmed robbery, which is a felony punishable by 15 years, is being charged. Count 2 also is assault with intent to do great bodily harm or murder by strangulation, and that is a felony punishable by 10 years.
Your
And
Honor,
then what?
he is habitual fourth man mid 25, so these crimes are each mandatory
Habitual-
minimum.
I'll get there.
Wait, habitual fourth.
I'm gonna get there, just,
Mandatory minimum 25 is what I
Thank you.
said.
I'm just reading that so he understands, okay? And then, so count 2 is a felony punishable by 10 years. Count 3, assault with intent to great bodily harm less than murder by strangulation is a felony punishable by 10 years. Count 4, assault with dangerous weapon, also known as felonious assault, punishable by 4 years. Aggravated domestic violence, count 5 is a misdemeanor punishable by 1 year. Count 6, domestic violence is a 93-day misdemeanor. However, you do have the habitual offender fourth offense notice. And it includes not just the fourth offense notice, but a mandatory minimum of 25 years, because on the primary offense, it goes from a 15-year to life. Well, it would start at 25 years minimum, mandatory. I could do more, but it's mandatory 25, and then I set life. So, sir, this heavy book that I am lifting is just the court rules. It's got some statutes in it. This is a little bit of an older edition. It's now gotten so large, they have put it into 2 volumes. And there are literally thousands of books that we get trained on, hundreds of books, millions of cases that we can review. There are unique arguments that may pertain to your case. You are not trained in the law. Here's what I do. So I want to have a conversation with you. Every judge does things differently, and I don't know how many judges you've been in front of, but you've been in front of quite a few. When someone wants to represent themselves, I give them standby counsel. I don't know if you want this set of counsel or someone else. I don't know what the breakdown is, nor do I need to know. But I give you advisory counsel so that you don't make an error. Because that error could be really prejudicial, and if the worst happens and you are convicted of one or all, and then you appeal, you have an automatic right of appeal if you go to jury trial. The Court of Appeals can look at this and say, well, you waived it by doing X, Y, Z. They might be not interested, even though it's an automatic right of appeal. So I don't want you to harm any of your rights. So I give you advisory counsel so you make the best possible record. However, I've been a civilian judge for 22 years, maybe 23, somewhere around there. And I've had a number of these cases. Each and every time someone represents themselves, I have had some kind of legal error that is harmful to their case, so we have to start again. It's okay if you want to try it. But if there would become some kind of legal error, I would have to call a second jury in so that you're not prejudiced.
Okay.
So then what happens is I don't let you represent yourself. You become second chair. Right now, counsel would be second chair and you would be first chair. Meaning counsel is there to simply assist and advise you. But if you mess up, I can't keep calling in jurors.
Yes, ma'am.
It's very costly, very time consuming, and quite honestly, it prejudices you and the victims because it will take a lot longer. For example, sir, about 5 years ago, I had a defendant who I thought should have been an actor instead of a defendant because he had a great personality, very humorous, and it's too bad he went the road that he did. But he decided to represent himself. And in his opening, he started talking about what happened and why this shouldn't have happened to him and didn't happen to him. And of course, the jury shouldn't convict him of a 20-year felony. And the jury is not allowed to know the punishment. So that was an error. And then he no longer could represent himself as I had to have a new jury because knowing that might prejudice the jury one way or the other. So there's a lot of rules. So if you really want to do this, I'm happy to allow it, but those are my rules. I've been upheld by the Court of Appeals on this process. Could always challenge my process, it's fine with me too. But I want you to be aware that there is some danger in you representing yourself, especially when you are facing this penalty. It's mandatory 25 minimum or more.
I understand.
So do you want to represent yourself?
Yes, ma'am, please.
Did anyone force, threaten, or coerce you to do this?
No, ma'am.
Did anyone promise you anything that caused you to make this decision?
No, ma'am.
Now, I don't know what the breakdown is. It might just be because they've talked to you about a plea, which they're obligated to do. Is the breakdown with these counsel here something where you don't want them to be second chair or
Yes, ma'am.
advisory? Okay,
Please.
counsel, would you agree with that?
I really haven't had much of a chance to work with Mr. Pitcher at this point, but if he believes that that is what he wants, then I am not going to object to it. I do realize he has been going through, we've had some changeover with his attorneys and there's been some delay. So I don't know other than that. Thank you.
Yeah, the changeover in the public defender's office is because they've had a number of very serious illnesses and a few deaths. And so that's why it's not,
Understand?
you know, not that they don't care about your case, it's acts of God that we can't.
Completely understand.
So have you had enough time to speak with counsel?
Yeah.
And you want neither of them?
No, ma'am. No, thank you.
So I do not know if they're going to be able to assign you, because there's such a shortage right now in their office, someone else from their office, and so we will contact as well, conflict counsel. Counsel, do you refer them out to conflict counsel if needed?
Your Honor, MIDC does not pay for conflict counsel, so I believe, and I could be mistaken, the funding would have to come from the court to pay for that.
That's fine.
But I'm sure we can coordinate the appointment process, but I believe it would come out of the court's budget to pay for conflict counsel.
Well, the court's gonna pay one way or the other by calling a number of jurors or conflict counsel, and he's entitled to have some kind of advice, and I'm not gonna have a 1 week or 2 week trial turn into a 6 week trial because of delays of things he doesn't know, so we're gonna pay either way, and so if you could assist in that process, that'd be great.
Understood, Your Honor. Thank you.
All right, so, you've made this decision of your own free will? All right, so let me also tell you, you're in the Michigan Department of Corrections.
Yes, ma'am.
You have contact with other inmates? Right?
Yes, yes.
You're wondering what the heck she's talking about. Well, here's what I'm talking about. They're not lawyers either.
I understand.
So when they decide to give you their 2 cents is $1 million worth of crap. Do not hang your hat on any of the crap they're spewing.
I don't share my personal details of, I'm sure you could understand with the details of this criminal case with anybody. So any choices that I'm making today is at my own free will, not with any influence, not with any advice by anybody else other than my own.
Okay, and that's good to know. I just want to say that to you because we have a lot of people who decide
Thank you.
that there are jailhouse lawyers with no training, and then
That's not
we see convictions out of that because they make the absolute worst
Yes, ma'am.
decisions.
No, I'm making this decision solely based off from what I feel is the right thing to do.
And that's your right, sir.
Thank you.
So what is the offer?
So, as court's already said, at trial, if found guilty, he is facing mandatory minimum 25 years, maximum of life. The original offer at the initial pretrial conference was 15 years. Then, I'm gonna be very blunt here, Your Honor. Keith Watson worked very hard to convince me to give this man a break. And I did. When we then came back here, I offered 5 years after consulting with the victim. And then Mr. Watson was able to talk me down to 2.5 years and 30 months. And this is not only to try and give this man a break, or to try and give this man a break, but also to spare the victim from any further pain. I want to be clear about something, and I want to make sure that Mr. Pitcher knows this. The assault and the unarmed robbery were caught on video. Crystal clear surveillance footage, and he already admitted in writing to assaulting her. So I'm happy to take this to trial. It will be one of the simplest ones I've done. But that's why I want to make sure he knows that this almost the entire crime was caught on video.
Let me stop you there. Have you seen the video, sir?
No, ma'am.
Why hasn't he seen the video?
I do not know, Your Honor. I will tell
Well,
you.
you're counsel.
I have not been able to get to see him. I've been trying to get with him with the MDOC and I've had difficulty trying to get that set up.
Well, there is a problem with MDOC.
I have
Great.
I already have that bit queued up. If they want to sit at council table, they can watch it off my laptop. It'll take 60 seconds.
Would you like to see it, sir? I mean, sir. 30 minutes, I don't want to talk into anything. But if it is as council says, you need to consider that. You need to see it. And you need to consider 30 months versus 25 years, which, let me just, that would be 300 months. So you got a 90% off deal. At least that's what my shopping math tells me. And I'm not good at math, but shopping math I can do.
I am, it's accurate.
Okay, good. So let's see it now. I want him to make this decision because I'm gonna move this case forward. You can stand there and look at it, or you can have a seat at council table, whatever you
I
prefer.
figured it'd be more appropriate for council to see it and not the court as well before the trial.
Yes.
Council
So-
table,
So where you
please.
gonna- Okay, do it at council.
Like I
table.
said,
That's fine.
60 seconds.
Go off the record. Right, right. But not everybody does that. Right, 90% off?
Okay. Figure out which one it is.
West. West.
Yeah, that's something like that.
Ready. All right, if everybody in the back can be quiet and have a seat. If you are talking, I will eject you from the courtroom. Sit down. We are back on the record. Mr. Pitcher, you're still under oath. Have you had an opportunity to see the video?
That's right.
Does that change your mind in any way, or would you like some time to consider it? We'll come back.
Okay.
You would like to proceed to trial?
Yes, please.
Offers pulled, let's get a trial date.
And you understand my hands will be tied if the jury finds you guilty.
Understand?
It's 300 months.
Yes, ma'am.
If you accept the plea, it's 30 months. You'll be out before you know it, and it would run concurrent with whatever you're doing now.
Okay.
Your Honor, if I may, I believe he's sitting on a, for lack of a way to put it, a flop on his parole, I believe, run consecutive.
Oh, all right.
Which,
But he's gonna be, when's he gonna be out?
but let me be clear, that was a large part of the reason that I went down from the 5.
I see. That piece-
Compensate for the amount of time that we've been having to wait because Mr. Watson convinced me to do so.
Okay, that piece was not made known to me.
He wants to go to trial. We're going to trial.
When's the
tried
trial
everything.
date?
We do not have one. We need to get one. And frankly, I don't.
Oh, no, we're not leaving without a trial date.
Oh, I know. I don't.
Pick one, or you want
Because
me to give
he's
you one?
representing himself and MBOC and needs access to the discovery that he clearly hasn't seen. I don't know how much time the defense needs. So
How much time do you need?
I'm allowed 4 hours a week in the law library, and it's all LexisNexis on a computer. So I have to request all of that paperwork. I just returned that same book. So that's what I have available to me.
So are you allowed to get on the internet?
Okay.
So what books do they have?
I have to request them. I have to request information to what books I have available to me, and then I just pick which book I want. It comes and I research it and I return it.
Okay. Talk to your advisory council. I'm sure there's several books they could recommend. I could recommend a few. I'd like to see you look at, but I can't be your lawyer.
I understand.
So for that reason, we are going to go to trial, and this may move because my judicial assistant's not here. I don't know what everybody else has got, but I'm going to give you September 18th trial date.
Okay.
That's plenty of time for you and your attorney to get your books, your 4 hours. If I multiply the 4 hours times all those weeks, I think that's plenty of time. Is that enough time, or do you want a sooner date?
Who would I would write to you directly or write to the clerk?
For what?
To ask questions if I'm making progress at a faster rate than I expected.
You talk to the prosecutor. You're
Okay.
really not supposed to have what's called ex parte communication with me, which is directly you talk to the prosecutor and say, will you agree to give me an extension, or is there an earlier date?
Okay.
But also talk with your advisory council,
Sure.
because they may say you need to look at this or that.
Is it okay if I ask questions now?
What questions do you?
When I
have?
send a question or anything, I have to make multiple copies, one for you, the clerk, for him.
No,
If you're
I'm
just
not,
asking a
I'm not.
question, we'll make sure that you leave here with my email.
I'm not involved in that.
Okay.
You all negotiate, I'm not,
Sure.
that's not my
That's fine.
function,
That's
okay? And if you send something to me, the first thing I do before I even read it is my staff copies it and gives it to all the lawyers.
Okay.
Because otherwise we're having communication we shouldn't have, okay?
Sure. Okay.
Now,
Your Honor, on that date, September 18th is a civil week. The following week, September 25th, those criminal.
don't care. You're a special prosecutor, you're on a civil week.
No, I just meant for your docket,
I know,
seven-
my civil cases never go.
Okay.
1% of them go, so I use my verticals. And then it doesn't overtax my
Wait,
docket attorney. And vacation? Do you have another trial?
having a kid,
When?
due date's August 9th, so I don't know when paternity leave will be. Happy to put that on for September 18th, and if need be, I will talk about it with my unit chief. Like I said, it's gonna be a pretty straightforward trial.
I mean, I can move it to October. I don't know how long your paternity time or what you're doing. Congratulations.
Thank you.
First child should make them early. And I want you to have some sleep, you know.
I'll get sleep now. October will
Oh,
probably
wait till
make
you have a
things,
baby, you're not getting sleep.
October will probably make things cleaner.
I'm sorry?
It would probably make things cleaner on my end.
All right. Let's try October 23rd. And then we'll deal with that. Again, my assistant's out, I don't know what, but we're gonna look at October 23rd. And if we need to move it forward or backward, we will.
Absolutely.
And that would be at 9 AM. Now, we're also going to do one other thing. as you do your research and as you meet with counsel, you may change your mind. This deal would scare me. I mean, 30 months versus 300 months. So I am going to give you what I don't often do, which is a final trial, but the circumstances have changed. I'm going to give you a final trial on October 7th at 10 a.m.
Your Honor, if I can be very blunt, a large part of the reason that we gave this offer was so the victim would have some peace. She doesn't have that anymore. So
She
that
doesn't
offer.
have that piece, however, she's got a change of circumstance here. You're not willing to.
I'm willing to
consider
hold it open for another month, but that is the kindest I can do here.
Well, if he only has access, let me just. Well, let me see, where are we? How about March 18th? Because the other thing is, you gotta deal with MDOC to bring them back here.
It's fair. March 18th will work.
March 18th is your final pretrial. So if something changes, you still get this offer, otherwise people are taking it off the table and I have no control over that.
What time, Your Honor?
Let's do 10 a.m. Anything else in the Any other questions, sir? Okay, you got a lot to think about. You got some homework to do. We're gonna get you that advisory council, okay?
Yes, ma'am.
Okay, and we'll bring you back, just I hate to inconvenience MDOC, but telecom's not always good. I know you have a right to be here in person, so we're going to exercise that as well, okay? That's all for the record.
Thank you.
Thank you, Your Honor.
Next, Nathan Carper, Your Honor.
Whatever this is.
Yeah, it is.
This is docket 2496FH, People of the State of Michigan versus Nathan Wayne Carper. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Carper, who is present standing at the podium.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, Your Honor.
Thank you. You put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with Mr. Carter?
Yes, Your
And you understand you're here for sentencing?
Yes, Your Honor.
And you pled no contest to count 1, criminal sexual conduct, assault with intent to commit criminal sexual penetration with habitual third, that is punishable by 20 years. You recall that?
Yes, Your Honor.
Have you had enough time to review the pre-sentence investigation report.
Yes, Your Honor.
Thank you. Any corrections, additions, deletions on behalf of the people?
Thank you, Your Honor. I believe that the box you just read from should read that it's count 2, that each listed count 1 was dismissed pursuant to.
That's correct. It's just, yeah,
It's charged.
yes. Got it. I've made that change.
Also on the cover page, Your Honor, under the plea agreement, I was just gonna fill in the rest of the agreement that was on the plea form.
Okay, before you do that, I've looked at the recommendation, the sentence, and I've changed it also on that the next page to count 2.
Thank you, Your Honor.
All right, and what is the rest?
It was further agreed the defendant will receive a PR bond with conditions of no contact with the victim, with a GPS tether, and victim notification, and that the defendant agreed to 5 years of probation, no contact with the victim.
And just to be clear, the 5 years of probation means no earned early release, no tether release, no, I'm with that, I'm doing half. I mean, if he's incarcerated for at any time, no, he doesn't get extra credits. He's, for a probation violation, I mean, and if, he does half the probation, he can't petition this court, it has to be the full 5 years.
That's correct, and I'm not sure under the circumstances that he would be eligible for the half discount, so to speak, so.
I'm not sure, just want to make a record just in case we can't say, oh, I didn't know, because
Right.
that is the common thing that probation does, and just so we know that's not going to be acceptable.
Correct.
Is that agreed to?
Yes, Your Honor.
You understand all that, sir?
Yes.
Okay, did you have any questions about what that means?
Yeah, I'll just be doing the whole 5 years probation
Yes,
in Cass County, right? That's the county. I'm in?
Yes.
Yeah,
and if you move, it could be a different county, you just need permission to move and all that, so.
understood.
Often, not in every case, but often, let's say I do 3 years probation, once somebody's successful, completes everything, they could get off after a 1.5 years. So someone might suggest to you during this time, well, you're doing well at 2.5 years, you should request to be released, but that's not the plea agreement. You have to do the full 5 years, you understand that?
Understood.
Okay. And that doesn't mean that jail or probation is off the table if things go bad. You understand that?
Yes.
Okay, very good. Okay, now that's full, fair, accurate, and complete. Are there any other corrections, additions, deletions, and do we need to also put that under evaluation and plan, or is this good enough on the cover sheet?
I'm satisfied that it's good enough on the cover sheet.
I think if you just made a note to add that to the evaluation and plan, you can save yourself some writing.
Okay. Any other corrections, additions, deletions?
Done on behalf of people, Your Honor.
I'm happy to defend it.
None,
What about as to the guidelines?
People had no corrections, Your Honor.
none for the defendant.
Do we have a victim here who wishes to address the court?
Yes, Your Honor. The victim is present. She has asked to have her statement read by someone, so if I may have.
Would you like to read it, or?
No.
All right, counsel, if you could have a seat with your client. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, the truth, and nothing but the truth, independent of perjury?
Yes, ma'am.
Thank you. Please state, spell your name for the record.
Shawnee's Wooten, that's CHAUNICE. I'm sorry, last name is WOOTEN.
And what is your relationship to the victim?
I'm the victim advocate with E.
And you are, you swear to read the statement as she's written it?
Yes, ma'am.
All right.
And slowly,
Yes,
I promise.
All right, thank you. You may proceed.
Thank you. This has been a long 2 years. This has taken up so much of my life. This whole process has broken me. Nightmares and night terrors of this night haunt me to this very moment. I can't eat, sleep is not a thing for me as I now have insomnia. My former Eve advocates have helped me with security items, as well as Sharon from Sparrow, who performed the rape kit, have all helped me feel safe and secure, and I thank them for it every day. The same exam was so traumatizing to me, I had to be given anxiety medications in order to get through the procedure. I still struggle with panic attacks, and with this overwhelming feeling of anxiety as this whole criminal court process has gone on. I hope to never again have to experience the invasiveness of having my whole body swabbed down. My body still feels like it's fighting, like I fought him off of that night while trying to call for help. While security devices and ring cameras have helped with making me feel safer, the PPO and the no contact order both solidified my sense of safety. Therapy helped with processing my trauma, the constant visits from the police, meetings with prosecutors, preparing for trial. It was best my EDMR therapy to be paused, and unfortunately, the program where I was receiving my therapy has lost funding, causing me to be without therapy after only 6 months. Not being able to process this for 2 years, not living a normal life, and living in fear of this person who did this terrible thing to me makes me want to tell anyone that this is not a good person and people should be warned about him. I hope this is my last visit to this courthouse. Between district and circuit courts, I have been to court over 20 times, causing me stress related to my job and eventually causing me to lose that job. This has affected my relationships, my mental well-being, and I am finally ready for this all to be over and done with. Thank you, Tricia Jones.
So I need to ask some questions. I know she doesn't want to speak, but is there restitution? Because technically the EMDR and all the therapy that would be covered, but there is a number and growing number, thankfully, of therapists in our community who do EMDR, and there's been great success. So that is something that funding began, he can pay.
Yes, ma'am. I will confirm that that therapy is now back on because the program did receive funding back and it is back on, but it is free and confidential for that person, for the victim, and at no cost for her.
Okay, are there any other costs that she has incurred, personal or property damage, treatment, co-pays, anything that he needs to be responsible for?
As discussed with the prosecutor, nothing that we know of.
Okay, and there is a plea here, there's also this sentencing. I do not know if a transcript would be helpful in her treatment or not, because he pled no contest, so I don't know, but would that be helpful or not?
I am unsure as I'm not her therapist, Your Honor, I'm sorry.
Okay, all right. And
sorry, can I ask a question?
Yes.
If she were to want it, is that something that can be requested of the court later?
Yes, I'm going to hold that reserve.
Thank you.
And is there anything else she wants me to know?
No.
And one other thing is, because this becomes a problem for the court, and I just want to say it publicly and have her hear it and you can talk with her about it, but the GPS tether with victim notification means that she needs to keep the tether company informed of where she resides.
Yes, ma'am.
And sometimes victims are shy of that, which means that can't be complied with.
Yes, ma'am.
So I'm sure you'll have that conversation with her or the people or somebody will.
Yes, ma'am. Thank you.
Would you like a copy? If you would give a copy of the court order, yeah, so she can contact us if she needs them. Thank you. Thank you. Thank you. I appreciate the victim writing a letter. And I know how difficult it is, but I also want her to know that she's safe, she's clean, she's whole, she matters. Nothing was her fault. And the way to take control and overcome this is to not let him take anything else away from her. Because the stronger you get, the weaker he gets. And it's gonna take some time to really fully understand that and feel that. But every day is a move forward, and even when you have days where you think you're moving backward, that's okay too. Those are teachable moments. Those are moments that you can talk about, learn from, so that you can continue to move forward. The idea is that you begin to live in joy, and it's going to take some time. If he does come within your zone, I want to know about it immediately. And dial 911. On behalf of the people?
Thank you, Your Honor. I would just like to piggyback what the court has said. Patricia's an extremely brave young lady. This case was a holdover from when Ms. McCray and I were assigned to your courtroom as your docket APAs that we kept the case. And we felt like after meeting Tricia and understanding the case and her views, that it was something we felt we should see through to the end. She's extremely brave. Many times she has said to us, she wants to make sure that the defendant is a registered sex offender so that the community at large is aware of his behavior and what he's done, and so that others will be on notice. That was very important to her. As the court has asked, and I can suggest or tell the court, we discussed restitution. She's out of pocket nothing. She wants nothing from the defendant except to be left alone. There's a $0 request for restitution. And I talked about and asked about counseling into the future. And she said she does not perceive that being an issue and does not want anything. Your Honor, the plea agreement was reached after much consultation with the victim, her family, her advisors, and everyone that assists her. She wants this to be over with, as you've heard from her statement. And so today's an important day, and finally she can get over not what happened, but just as part of what happened, and move on, at least from the court part of it. Your Honor, I'm asking the court to follow the recommendations, a review of the PSIR, and I do give the defendant credit for being extremely truthful in his reporting to probation. He needs a significant amount of treatment and counseling as it pertains to sex and sex offending. And I'm asking the court to adopt the recommendations and let probation deal with it from there. Obviously asking for the tether, the GPS tether to continue. It's my understanding the defendant has a lot of contacts in Indiana. He lives right down by the border. I don't necessarily have a problem with the court continuing to allow him to go to Indiana for work or pre-approved situations. And I think it's great that he's out of the area. So with that, Your Honor, I just ask the court to follow the recommendations and sentence the defendant per the PSIR. Thank you.
Thank you. Counsel?
Do you want us back at?
Yes, please. Counsel, what would you like me to know?
Thank you, Your Honor. I would also ask the court to follow the recommendation. I did discuss with Mr. Berman the issue with Indiana. He lives like right on the border of Indiana. Shopping is closer to Indiana than it is in the next available shopping area for my client. He banks in Indiana. His job, he's a technician for trailers. He helps build RVs. Those factories are in Indiana. So I'm asking the court to allow him to be at least as far as the GPS location is, to allow him to go to Indiana. It's much further away from where Leslie, Michigan is. I don't think my client will be visiting up here in the Lansing area except for court hearings. And I would ask the court to amend his probation conditions to allow him to go to and from Indiana freely.
Sir, what would you like me to know?
I just wanna accept the responsibilities for my actions and move on from this and just to be able to go to Indiana, seek employment. Just move on from all this.
So talk to me for a minute about your substance use issues. What's going on with that? Have you been in treatment?
I've been in treatment before with alcohol. I never started to touch meth until I was about 30, 32, somewhere in there. And I was incarcerated for good periods of time off and on throughout my 30s. And meth has always been a factor, an issue for me eventually at some time.
So why do you need to check out with meth? You know, meth kills your brain.
Absolutely.
I mean, if your brain's a grapefruit, it can shrink down to like a little lemon. And it's never gonna be a grapefruit. Why are you killing yourself? Do you know?
Just numbing myself from reality. If the problems are still there, it's just a terrible choice I've made that I don't want to go back to for sure.
Okay, so you don't have to tell me what the problems are, but you're numbing yourself from problems is what I just heard, right?
Yeah.
Why not address the problems and have a healthy body, brain, and a life that's not going to be in prison? Is that tough?
No.
Then why haven't you done that? Did you not think asking for help was an option?
When you're under that substance at the time, that's the last thing you're thinking about. It's addiction.
I get that.
Yeah.
But sir, as I'm sitting here, everybody's got problems. The last thing on the very planet would be, I'm gonna use meth to get rid of my problems. I'm gonna ask for help. I'm gonna read a book. I'm gonna do something. Did you try anything prior to reaching for meth and then ending up in assaultive behavior? Are the problems so overwhelming that you can't ask for help?
No.
Then what's the holdup? Is it because you think that as a man, you should be able to deal with everything yourself?
No.
Then what's the issue? Do you know? You
It's,
don't have to know. I want to know if you know or don't know.
Right. No. I just get around the wrong old friends I have. I'm not right now at all. I'm sober and I plan on keeping it that way. It's just, it can be like just passing someone at a gas station. It was like the last one when I was out on felony probation. And that temptation just coming across, I know what it's like to let myself down now after a good period of sobriety from being incarcerated. And I'll be honest, as soon as I hit the pipe, I was like, yep, I am so going to jail. Like, I knew I messed up.
So what you're doing is you're giving your power and your choices over to your friends.
And I did, I made that mistake.
Yes.
I know what it's like to let myself down with that now. I don't want to do that again.
You also let the victim down in a big way. You altered her life forever. You haven't just killed part of your brain. You altered her life forever. She will never feel safe. She has a lot of work to do that she shouldn't have to do. She will never forget this. Even when she thinks she forgets it, she's going to smell your cologne or see someone who looks like you, and she's going to be triggered You caused that. She did not deserve that. No one deserves that. It's as simple as you asking for help. It takes a man of strength to ask for help. It takes a man of weakness to use substances, to hide behind them, and to assault a woman. And I suspect that if someone treated your sister, your mother, your auntie, some woman you love, the way you treated the victim here, you'd be the first one up here saying, Judge, I have a lot to tell you because I'm mad. How do you think she and her family feel? How do you think her mother feels about what happened to her daughter, about what you did? Sir, this is clearly troubling. Do you have children?
Yes. Have 3 boys.
And are they in your care and custody? Are you married to the mother?
No, I'm divorced from both of them. I have 2 with the first ex-wife and 1 child with the second.
So do you see your children?
I spoke to my oldest this morning.
Do you have a relationship with them?
Yes, it's been rough because I've been in some situations for the past couple of years and not in their lives. Yeah.
Are you paying support?
Yes.
Are you behind in
I'm
support?
ordered. Yes, not by much, but I am ordered to pay. I do have employment lined up at Alliance RV. They just wanted to have all the court dates and any reason I should miss work. They wanted all that out of the way. They're pretty strict with attendance within the first 60 to 90 days.
All right, sir, you are on probation for a term of the full 60 months. You cannot be released early for any reason. You shall not violate the laws of this state or any other. You will complete sex abuse prevention programming and any other treatment you're told to take or recommended to take by probation or that programming. You must register as required by the Michigan Sex Offenders Registration Act and comply with all requirements of that act. You must provide a completed copy of the Michigan Sex Offenders Registration Form to your probation agent on your first in-person report following vacating your residence, any address change, address verification, or change in your status with an institution of higher education. At each address change or verification period, you must present your Michigan operator's license, chauffeur's license, or personal identification card to probation at your first in-person contact. To facilitate sexual offense caseload case management team CMT meetings, you must waive confidentiality, sign all necessary releases, and allow the disclosure and exchange of information between the Michigan Department of Corrections, including its authorized agents and all CMT members. You will not leave the state without the consent of this court. However, I am allowing you to travel to Indiana for work and personal business. You will keep probation advised of your work schedule. I'll allow you to travel for, I guess you do your banking and personal needs over there because of location, but this is not a free for all. You're not driving to the other end of Indiana. I mean, this is really to take care of your life needs. Okay, we need to monitor you, and I don't know how Indiana is going to feel about this, so you'll have to work that out. Probation will help you work that out, okay? Because there's compacts, and I don't know if they allow you to travel freely or not. Every state has their own rules, so you'll have to abide by those rules. This can be transferred to Cass County. However, how it works, sir, is that you will need to meet with probation here, and then it gets transferred to Cass County. Because if I just say transfer to Cass County and you show up, they don't know who you are. So today, before you leave, and your attorney can direct you downstairs to probation, you can make and keep that appointment. It's okay if you do it on Zoom. I've been to Cass County. It's a beautiful county. They have a beautiful courthouse out there when I was in practice. And so I know it's quite a distance away. So I'm not asking you to have to come back here. But if they can do that interview to get you all situated on Zoom, that's fine with me. And then transfer to Cass County. Does that make sense to you?
Yes.
Okay. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. If you end up needing alcohol or marijuana as part of treatment, you'll use it only as provided in the prescription from a licensed medical physician. You can use over-the-counter medications as labeled on the bottle, and you can use less but not more. You will not adulterate any testing. You will be regularly tested. And at this point, I'm going to say you're going to be tested Monday, Wednesday, Friday, and random on the weekends until probation is satisfied that you are clean. And I'm doing that so that you know you can work your work schedule. So otherwise you call every day and then it might interfere with plans, but Monday, Wednesday, Friday, then random on the weekends. If it is positive, you have any drug or alcohol test that is positive, you will pay for a secondary test so we can see if it's positive, or false positive. Once probation and your treatment providers are convinced that you're doing well, they can reduce that. You are going to attend AA, NA, or CA at the frequency recommended. And you will have a sponsor within 180 days. The sponsor must have gotten clean and sober by going through a program, and they must be clean and sober for 5 years. So, sir, that way, if you're having a bad day, you can call them. Do you have a sponsor now?
No.
Okay. You will make a truthful report to probation and all treatment providers. You'll meet with probation no less than monthly. And if they want you to meet more often, then you will do that as well. And you will complete cognitive behavioral. That's probably part of your other treatment. It usually is, but you will complete that as part of another program. That's fine. You will comply with the Michigan Department of Corrections electronic monitoring program as directed by probation. You notify probation immediately of any change of address, employment status, or cell phone. You must not have verbal, written, electronic, or physical contact with Tricia Jones, either directly or through another person, and you will not be within 5,000 feet of their residence, school, or place of employment. Now, I don't know if GPS teller at 5,000 feet is something that they can do. If not, it will be 2,000 feet or whatever the longest distance is that they can monitor. And it will be a GPS with victim notification. If for some reason you end up at the same Myers, you leave. I don't care what's on sale, you do an about face and you leave. You end up at the same church service, you do an about face and you leave. No messages through smoke signal, carrier pigeon, Hallmark cards, flowers. She doesn't exist in your world any longer. Do you understand that? Because if you end up having contact with her directly or through other parties, there will be an immediate probation violation hearing. And you will not like the outcome. Do you understand?
Yes, sir.
You must possess a valid Michigan driver's license or personal identification card and keep that on you at all times. Do you have one?
Yes, sir.
You will not engage in any assaultive, abusive, threatening, or intimidating behavior. Ms. Jones is not requesting any restitution. However, if the money needed for treatment is not available, you will be paying for that treatment. She can present receipts to the crime victims advocate. And then if you object to it, your attorney will let me know. We'll have a hearing. And that amount can go up, it can go down. If she requests for treatment, a copy of the plea and or sentencing, then you will pay for a copy of that transcript that will be transmitted to her sealed, and she can then use it for her treatment. It's often helpful because many victims do not remember what happened because they are so traumatized, and that way their therapist can work with them. She is in the process of turning from victim to survivor and thriver, and I want to keep her on that path. And that is why I'm ordering that, because but for your actions, she would not be on that path. She would be thriving in her life. She has to get back to that. So whatever tools she needs, you'll be paying for. I'm going to leave that open during this probation. I doubt she's going to request it, but if she does, she's entitled. Understand, sir?
That's right.
And I hope she does request it, because you need to pay, sir. You will not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Corrections or who's on probation or parole without permission of probation. That would only be if you're all in good standing, and will not also be with anyone who's violating any criminal law of any unit of government. You will have no contact with any known gang members. You'll not wear any gang colors or gang tattoos. You'll contact probation today before you leave this building. You will comply with all written and verbal orders of probation and all treatment providers. Those become orders of this court. You must allow probation into your residence at any time for probation supervision, and that would be without a warrant, and submit to a search of your person and property, including but not limited to your vehicle, cell phone, residence, and computer. If probation is reasonable cause to believe you have items that might violate the conditions of your probation. Counsel, was there an AIDS STD test that was requested?
Yes, and my client did have that, and I instructed him to provide that information with the probation officer.
All right, thank you very much. You must report any arrest, police contact, loss of employment, personal protection order placed on you, or change of residence to probation within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday. If Monday's a holiday, tell us on Tuesday. You will serve 706 days jail with credit for 706 days served. So you're out of jail time. If something really bad happens, it would be a prison term, sir.
Your Honor, if I may,
Yes.
can we change that to 365 days with 706 days
Sure.
served? I'm just afraid that the way it reads, it's a
Yeah.
prison sentence.
I wondered about that, but all right, yeah, we'll change it
Unless
to
Mr.
365 days with credit for 706 days. You'll pay a crime victims amount, you have in the amount of $130 and $68 state cost, so that's $198. I'm waiving any other court costs or other costs. Are you able to pay your bills, sir?
I'm not employed right now.
Okay, I'm waiving probation oversight costs. If at any time you are able to pay and that determination is made, then that can be on the table, but right now I'm also waiving that. So your only cost right now, aside from restitution, is $198 mandatory cost, which you'll have 5 years to pay, so you can return.
Which you'll
pop
have to
outs.
what?
You'll have the 5 years to pay, so you can return pop outs and pay it for all I care. You will not use any object as a weapon, you'll not own, use, possess, or have any type or imitation thereof of any ammunition, firearm components, firearms, you'll not be in the presence of anyone who has those items, will not use any object as a weapon. You will complete the 180-day, well, I don't know if he's so far away, does he need that tether?
I just want the GPS tether with the victim
Yeah,
notification.
that the MDOC, I think the GPS tether's fine. And then, sir, you will comply with all orders of all courts, including paying your child support, and you will not have a dating relationship with any woman with a minor child. And if you do have a relationship with a woman with a minor child, you'll let probation know. And then that minor child will not be present, and if they are present, then the responsible adult, guardian, parent must be present at all times. You have 42 days to appeal and to request appellate counsel. Is there anything that I have missed or need clarification of?
No, Your Honor.
Not on behalf of the people, Your Honor, thank you.
On behalf of the victim, I see the advocate standing. Is there anything?
I just wanted to make record that there is a protection order in place that is set to expire July 17th of 2026.
Okay, thank you. And the no contact order has much greater penalties, so although the PPO is good, we also have the no contact, which will remain in effect and will not expire during the pendency of this.
Understood, thank you.
All right, just so she knows. All right. Do you have any questions, sir?
No, Your Honor.
Please go downstairs and to acknowledge the receipt of the appellate orders or rights, that form. If you want to appeal, you have 42 days to appeal and to request appellate counsel. Do you acknowledge the receipt of that? That's that document right there. So if you're
Do
unhappy
you
with this.
acknowledge that you have this piece of paper in your hand?
I don't even know what it's for.
It's for appeal. If you're unhappy with anything, and Mr. Carter can talk with you about this outside, but if you're unhappy with any of this, you have to file that document for court-appointed counsel and for the appeal within 42 days. You have 42 days to think about it, okay?
Yep.
Mr. Carter can advise you further, but I'm going to ask you now to go downstairs and keep that appointment with probation. Mr. Carter,
Thank you, Your Honor.
that's all for the record.
Thank you, Your Honor.
This is docket 24786 FH and Rich.
No, what are we doing?
Over. This is docket 24786 FH, People of State of Michigan versus Jason Hulbert. Counsel, your appearance for the record.
Good afternoon, Your Honor. Robert Ioni, Special Assistant AG on behalf of the people.
And good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Holbert. Mr. Holbert should be on Zoom, Your Honor, with the court's previous permission because he lives out of state.
Mr. Hulbert, are you on Zoom?
I am on Zoom, Your Honor.
All right, let me see, Brian. Would you allow him to?
Should be able to do it.
Okay, sir, I just need to see you.
It says that you guys have disabled, oh, there we go.
Yeah, I'm asking the, there it is. Okay, all right, very good. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Ready to put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor. No, Your Honor.
Have you had enough time to speak with your attorney in regard to sentencing?
I haven't spoken with my attorney, but I understand what's going on.
I'm sorry, sir, you gotta stay next to your microphone. I didn't understand that, nor did the court reporter.
I haven't spoken with my opportunity.
Sir, we're not understanding you, so unless you wanna come into this courtroom, I need you to stay by the microphone and talk a little bit slower and enunciate, because we're not able to understand you, so start again.
I haven't spoken with my attorney as of yet, but I am right.
I think I know what he's trying to say. My understanding from you, Mr. Holbert, is we have not spoken regarding necessarily your sentencing date here today. I did reach out to you, did not hear back, but I have sent you a copy of your PSI. Do you want to discuss it any further, or are you ready to proceed with your sentencing today?
We don't have to discuss the PSI anymore. We can proceed with sentencing.
All right, in the future, Ms. Schroeder, if that happens, just while we wait, get in a breakout room, go in the back, and let's deal with it, so we don't waste time on the record.
I understand, Your Honor. I did not realize he was waiting on Zoom.
Okay, well, he was scheduled to be here on Zoom, wasn't he?
He was, Your Honor. I just was not made aware he was here.
Yeah, but it's not our job to come find you. You come find Brian or someone on my staff, and we're gonna tell you.
I understand, Your Honor.
All right, and pass that on to your staff, because these delays are, it just costs us some time. All right, and I know you usually talk to people, it's just, you don't know, just ask, because I'm not a mind reader.
I understand.
Very good. Sir, you pled guilty to count 1 child support failure to pay, punishable by 4 years. You recall that?
Yes, Your Honor.
All right. And on behalf of the people, are there any corrections, additions, deletions?
None, Your Honor.
On behalf of the defendant, are there any corrections, additions, deletions?
No, Your Honor.
And as to the guidelines?
You're scored properly, Your Honor.
I would agree with that.
Thank you. And on behalf of the people, there was an offer that if it would be pled down to an attempt, if he pays down the arrearages, has he paid down the arrearages or paid the full amount? So it would be reduced to a misdemeanor? What, can you tell me?
He's made remarkable progress towards making regular payments, but he has not been able to reach the threshold to secure the attempt, Your Honor. He started this case out, he owed it in excess of $26,000. It's currently at $17,696. So he is making progress. He has been making payments. We have gotten his attention, but unfortunately, he has not achieved the number to get the attempt.
Okay, and you're not offering that despite him making this?
That's correct.
All right.
And we had, Mr. Holbert and I have previously discussed that, and he understood that was his situation. So thank you.
All right, thank you. And do we have a victim here? Or, and there were no changes to the guidelines, correct?
That is correct, Your Honor.
All right, Cheryl, do we have a victim here?
I don't see her, but I want to double check. Is April Kilowald in the courtroom?
Or on Zoom? All right. On behalf of the people, what would you like me to know?
We're asking that the court follow the recommendation with the addition of rearage restitution amount of $17,696. I noticed the recommendation does include the reimbursement to the state of Michigan for the cost of extradition. We're asking that be included as well. Right? It is in the recommendation.
That would be the $3,280 for being apprehended by the fugitive team.
Correct.
All right, so how I do that, I think you're well aware of this, is that would be paid after child support.
Absolutely.
Yes, thank you. Counsel?
Thank you, Your Honor. Mr. Holbert took care of, I understood it took us a while to get here, but he did take care of what he needed to with regard to the sentencing in terms of the report. I'd ask the court to adopt the recommendations. He has been making payments. He is fully employed now. I believe he did sign off on a garnishment as well to get himself on a better track. He has support down in Florida. I would ask the court to adopt that recommendation and allow him to be on probation through the interstate pact for me.
Thank you. Sir, what would you like me to know?
Just your, as they've already said.
Sir, wait. I, again, didn't understand you. Just, even if you look bent over, I need you to be by the microphone, slow and enunciate. Sadly, while Zoom is terrific, okay, it doesn't always come through clearly. We're live streaming, still doesn't come through clearly all the time. So just be cognizant of that so you don't have to fly down here, okay?
I understand, Your Honor. Thank you.
What would you like me to know?
So due to what the prosecutor has already stated, I have been making great progress with the case. I know that it's a big sum.
I've been making progress. Again, you can go down closer to the microphone and go slower so we get it.
Just that I've been making progress. I also have full custody of my 7-year-old child, and just ask that the court allow me to continue working on this so that I can bring this debt down.
So let me just ask you, when did you get custody of your 7-year-old?
It was given to me full custody here right before
I didn't understand. Given to you when?
right before December.
Okay, has child support been amended as of that date?
The child support wouldn't apply to this. It's a separate child, Your Honor.
It's a what child?
Separate child. He has another child, and the child that's involved in the support order is a different child.
Okay, but now that you have custody of another child, that would warrant review of child support here because you have another person you're paying support for. And sir, it only goes from the date you request. So you need to request the Ingham County Friend of the Court to review your child support that's due on an ongoing basis. It would not affect the retroactive, what you are behind in, but going forward, I suspect there may in fact be a lesser amount due, but it will not happen automatically. You have to trigger that by letting them know. Do you understand?
Yes, Your Honor. I was assumption that the total that I already owe for children who are all over the
Sir, you were under the, sorry, again, you gotta stay by that microphone. You were under the assumption what?
that the totals that I owe for the child support won't go up because he's over the age of 18 anyway.
Because the what? The totals won't go up because it's over the age of 18?
Correct, so.
If I'm understanding you, where the case that you have the arrearage in, the children are all adults, is that correct?
That's correct.
Okay. So you have this case and then you have another case or another child. Is that the only friend of the court involvement you have, or is there other children?
No, that's the only ones.
Okay, very good then. And on behalf of the people, I take it you're doing the tax interceptions, et cetera, so he might not need the full 36 months, but I'm gonna give him the full 36 months.
I think he probably will need it, but in any event, he's able to satisfy it earlier, then we can come back and he can come off probation.
All right, thank you. Sir, you'll be on probation for 36 months. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. And the reason is that it looks like you've got quite a history here, but also if you have money for drugs and alcohol, that money needs to go to pay your child support, although it looks like you've been clean for some time. If at any time you are found to use any illegal substances or alcohol or marijuana without a prescription, then We'll have your regular testing, treatment, and monitor that very closely. You will obey all court orders and all recommendations of the court. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You'll contact probation within 24 hours of your placement on probation. So that number is 517-483-6100. We need you to contact probation. This matter can be transferred to Florida, but not until you meet with probation, because Florida does not know about this. And we have to follow the interstate compact rules. You'll comply with all written and verbal orders of probation. You'll allow probation into your residence at any time for probation without a warrant, and submit to a search without a warrant of your person, property, including but not limited to your vehicle, cell phone, residence, and computer without the need of a warrant of probation as reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence within 24 hours. Weekends and holidays are accepted. So if something happens on Friday, tell us on Monday, Monday's a holiday, tell us on Tuesday. You will serve 365 days jail with credit for 32 days served. The balance is held. You'll pay a crime victim's assessment, the amount of $130, and a $68 state cost. That's $198. I'm waiving probation oversight fees. You will pay child support and related expenses as ordered by the court, and you will pay the state of Michigan Attorney General's office $3,280 for cost recovery for the extradition. The extradition, as well as the state cost and the crime victims, will be paid after the child support is paid, and we will not hold open probation for those purposes if the child support is paid. However, they can get their money through tax collections and other ways. You'll not use any object as a weapon. You must not own, use, possess, or purchase any weapon, have them in your presence, under your control, imitation of a weapon, ammunition, firearms of any kind, or use any objects as a weapon. You will not use corporal punishment. You'll comply with all friend of the court orders, and that would be for the child in your custody. And if you at any time lose your employment, you will be part of a work seek program. You will not give your employer any cause to terminate you. And you will maintain a wage assignment for all of your jobs and report all of your jobs to the friend of the court so that appropriate action can be taken for collection. You have 42 days to appeal and to request appellate counsel. Is there anything that I missed?
Can we get restitution in the amount of your wage, Your Honor?
Well, the restitution would be at the child support, right?
Correct.
Yeah, so he owes the child support, whatever that is. What is the current balance?
17,696.
So that would be 17,696, and that would be owed. Yeah. Anything else?
No, Your Honor, thank you.
Right, so you have 42 days to appeal to request appellate counsel. Your attorney will file with us proof of service that she has provided that to you, unless you've already provided that to him.
I have not yet, Your Honor, but I was about to actually say that. I will be providing it. My apologies.
If you provide that to him, and then just give us a proof of service so we know that was completed.
Yes, Your Honor.
Any questions, sir?
No, Your Honor.
Thank you, good luck, and this can be extended up to the 5 years if you don't pay, so let's get this done. I think that you're on your way and you'll get it paid in the required time. You'd be released early if everything's done, all right?
Yes, Your Honor. Thank you.
Good luck to you, sir, thank you.
Thank you, Your Honor.
Thank you.
That's all for this record. Next, madam.
Ortiz Anderson.
Give me a minute, please.
Brought in Judge Stephen. About 3.5 minutes ago.
This is docket 24712 FC, people of the state of Michigan versus Ortiz Anderson. Counsel, your appearance for the record.
Your Honor, good afternoon, Deputy Chief Assistant Prosecuting Attorney William Creno on behalf of the people.
And thank you, Your Honor, Jared Austin appearing on behalf of Mr. Anderson. He stands present to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, you had a jury trial and the jury found you guilty of count 2, weapons carrying concealed, punishable by 5 years. Count 3, weapons, felony firearms, punishable by 2 years. Count 5, assault with a dangerous weapon, also known as felonious assault, punishable by 4 years. Count 6, weapons, felony firearms, punishable by 2 years, and that would be 2 years consecutively with and preceding any term of imprisonment imposed. And finally, count 7, assault with intent to do great bodily harm less than murder or by strangulation, punishable by 10 years. Do you recall that?
Yes, ma'am.
Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Have you read the pre-sentence investigation report?
Yes, ma'am.
And you're prepared for sentencing?
Yes.
The court should also note that I'm in receipt of a red folder. I believe the people also have the information, but it was provided to me by counsel for defendant, and it has, I don't know, you didn't count, but I read probably a dozen different letters.
Yes, Your Honor, there was provided to me by a group, and I think it's also a combination of Mr. Anderson's family provided some additional biographical information about Mr. Anderson, along with some community and character and support letters.
On behalf of the people, have you received these? Would you like to review them?
I've received a copy. Thank you, Your Honor.
Thank you. Are there any corrections, additions, deletions?
Your Honor, thank you. There are a number of corrections to the report and to the guidelines. I'm going to defer to Mr. Austin. Almost all of those are by stipulation, except as to one grid, and that would be related in relationship to the CCW. So everything else would be by stipulation. I'll let him put that on.
All right, thank you, counsel. You may proceed.
Yes, Your Honor. As it relates to the factual content and body of the report, I'll begin with that first. Starting with the cover page, the box at the top under current convictions, the assault with intent to do great bodily harm less than murder, they have listed that as count 7. That should be count 4. It does appear correctly, I believe, throughout the remainder of the report as count 4, but it's incorrectly listed there.
Just a minute. So, yes, and they also did it under the plea agreement correctly, so.
Yes, and in the body of the report as well, that seemed to be the only place where it was misnoted as count 7. Right underneath that, Your Honor, under the plea agreement section, it makes reference towards the end about the bench warrant to be held in abeyance for witness Jordan Glover, and to be filed December 8th, 2025 at 9 a.m. if witness fails to appear, remanded to ICJ. While that is factually correct, it is really irrelevant and not
Court would
appropriately.
agree, I'm striking that.
And those exact same sentences are found in the body of the report, Your Honor, under the first paragraph of evaluation and plan. We would be asked that they be removed from that portion as well for the same reasons.
So struck.
And while we're on that same page, Your Honor, page 1 of the evaluation and plan, I'll be referencing the paragraph entitled additional information.
Yes.
Towards the middle of that, where pretrial services is discussing one of Mr. Anderson's PA 53 violations, where it says new criminal charge regarding alleged possession of a firearm and PA 53 violation. He did have a PA 53 violation that was later dismissed involving firearms, but there was never any new criminal charges that originated from that. So I would ask the reference to new criminal charge regarding that be struck because it is inaccurate.
And remind me, what did we do with the PA 53 violation?
It was set for a contested evidentiary hearing, Your Honor. The necessary law enforcement witnesses failed to appear for that hearing, and that was subsequently dismissed.
Then I'm just simply striking that whole sentence. Is that acceptable on behalf of the people?
No objection, Your Honor.
Thank you.
And I just had one other brief changes to the body of the report, Your Honor. This would be found under the employment section.
Yes, sir.
Mr. Anderson tells me the employment they have listed is actually transposed. His Meyer warehouse employment should be the most recent employment he has, and his retail employment would have been earlier. So I think those need to be swapped.
So the rest of it's just the employer name needs to be changed, the dates, pay, all that is correct.
Correct, Your Honor. The Meyer warehouse and the information that accompanies that is correct. I think it should be, Mr. Anderson tells me it should be in the 2025 date range, the one where they have for the retail fraud. And then the retail fraud, or not, I'm sorry, not retail fraud, but retail employment should go from the start date of the November 1st.
Okay, I got
through the
that.
January 1st.
Is there a specific retail or is it the business called retail? Was there a specific store, sir?
I don't remember the story.
Okay. Okay.
With that, Your Honor, I believe that covers all the changes as to the factual content or to the body of the report. We do have some changes to the guidelines, as Mr. Carino indicated. Most of those will be stipulated to. I am prepared to address those.
Okay, and sir, did you finish your GED?
No, ma'am, I was working on it on the house.
Okay, very good. And let's go to the guidelines.
Yes, Your Honor. I'll start at the back under the assault with intent to do great bodily harm less than murder.
Okay, let me go in there. Got it?
Sure. OV 6, offense variable 6 is scored at 10 points. The parties agree that that should be 0.
Change has been made.
OV 9 is scored at 25 points. We believe that should be 10.
Change has been made.
That would bring the total OV points to 50 and denigrating it from a level 6 to a level 5.
Range?
That would change the range to 19 to 38.
Changes have been made.
And backing up to the felonious assault.
Yes.
OV1 is scored at 25, and I believe the parties are in agreement that should be 15.
Change has been made.
OV3 is scored at 10. Parties would agree that should be 0.
Change has been made.
OV9 is presently scored at 25. The the parties would stipulate to the scoring of 10.
Change has been made.
That changes the total OB points to 30 and the level to 2.
Changes have been made.
And the guideline range would change from 2 to 17 to 0 to 17.
Changes have been made.
Thank you, Your Honor. And now to the contested ones we have, that would all be found under the CCW.
I'm there.
And my argument for the variables is going to be the same. The law says that for this, the conduct scored for this particular offense has to be limited to the sentencing offense per McGraw. And in my opinion, the scoring of OB 1, 3, and 9, they are essentially looking to conduct beyond carrying of a concealed weapon to justify the scoring of those. They are essentially scoring him for facts and factors that are essentially taken from some of the other charges he was found guilty of. And I think where the parties are in disagreement, to my knowledge, there has not been any subsequent body of case law that further defines what is meant by sentencing offense. The way I would read that is that that should be limited to the facts and factors to that particular charge and to the elements of that charge. There is a case on point, the Biddles case, which is a published case where in that instance, the defendant was found guilty only of felon in possession of a firearm, and they were attempting to score him for other similar variables for charges in which he was acquitted of.
But that's not the case here. He has not been acquitted of these others.
I agree with that part, Your Honor. But the point I'm trying to make, when you, I think, look at that case and the language in that case, what I'm saying is I believe that it, at least on a strict construction of the language of the statute, would support that particular position, where I believe the people have the position that by limiting it to the sentencing offense, it has a more broad application. In other words, the court can look at the totality of the facts and circumstances of any other charges he may have been convicted of, is kind of the whole big picture aspect. But what I see limited to sentencing offense, I believe when they're trying to score him for those serious variables, that goes well beyond the sentencing offense of just carrying a concealed weapon.
Well, I'm gonna hear from the people, but my interpretation would be, and I respect that case, but these are offenses that stemmed out of the same occurrence and was found guilty of. So I think they all are looked at together, but I would like to hear from the people.
Your Honor, thank you. The reliance on McGraw and Biddles is misplaced, because what those cases are about are cases where there's acquitted conduct that the people attempted to score, and that is certainly not the case here. The court's analysis is absolutely correct. We score sentencing events. Otherwise, Your Honor, what would be the point of, for example, crimes against public safety allowing a variable for offense variable 1, aggravated use of a weapon? You could never have a circumstance where you're convicted of CCW where you score offense variable 1. The legislature has built that in. So I think the reliance on that is misplaced. I think the court's analysis is accurate, and I would ask that the court score those consistent with what we have here: 25 points for OB1, 10 points for OB3, although I would concede that OB9 should properly be scored as 10 and not 25, which would reduce the level somewhat.
My ruling stands. You've made your record for appellate purposes. I agree with what the people said, and I've already told you my feeling about it. OB9 is 10. That makes OB, the total OB is 50. And what is the level?
I think it makes it
45.
45, Your Honor. So let's just double check.
I'm sorry, 40,
Yeah.
45, yes.
Along that, I know, just 1 second.
Yeah.
45, the range would be
5 to 23?
5 to 23 still, yes.
But the level stays 5.
The level moves down to, offense variable 4, 5 to 23.
Okay. So now I just need a minute to change the basic information sheet, so it's consistent with what we just did. Basic information sheet on those 3 counts is consistent now. And then under recommendation narrative, we also need to make the corrections. Round 2 is now 5 to 23. And 5 is right.
I guess while we're under the recommendation narrative, Your Honor, I do see where they have count 7, I think that should be count 4.
Oh, yes, let's change that. So where it just was. Okay, so count 5 is zero 17. 19 to 38, and it would be count 4. So I think I've got it all consistent. Okay. Any other corrections, additions, deletions?
None on behalf of Mr. Anderson, Your Honor, thank you.
None for the people, thank you.
We have a victim here who wishes to address the court.
We do, Your Honor, yes.
Counsel, please have a seat.
All right, thank you. One of the crime victims in this case, Miles Washington, his mother, Alicia, Elicia Ortiz, Ortiz, is here and would like to address the court, please. I'll bring her up to the podium.
Thank you for being here. Please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, sir.
Please, you may put your hand up. Please state, spell your name for the record.
Alicia, first name Elicia, last name Ortiz, Ortiz.
What would you like me to know?
Your Honor, on behalf of my family, would just like to express to the court the toll this is taken emotionally, mentally, and physically on my son, as well as our family. Not only did Miles go through physical pain after leaving the hospital, but he has suffered emotionally and mentally. He had issues with lack of sleep. When he was able to get sleep, he had nightmares. He has expressed his anxiety to his father and I. He has reached out expressing that he needs help. We have struggled trying to cope with what happened. Constant visions of that night, the videos replaying in our head, recalling times I've seen on the news of people being beaten and dying from less than the amount of people that my son was beaten by.
That my son was what?
Beaten by. Wondering if I'll ever be able to not break down at any time.
Certainly.
Recalling times that I've seen people on the news that have been beaten and have died at the hands of less than the amount of people that had beaten my son. Wondering if I'll ever be able to not break down at any time, any given time, thinking I almost lost my son not once but twice. This could have been anyone. Given what started the situation that led to this individual's actions, this could have been anyone. And what is so upsetting and frightening in society to bump or to say something that one does not agree with, that this is the reaction that will come from this individual. This could have been anyone. We ask the court to impose the maximum sentence possible to ensure our safety and the safety of the community as well.
And the safety of whom as well?
The community.
Thank you.
Thank you.
Thank you for being here. I appreciate you speaking out, not just for yourself and your family and your son, but also for the community, because this is literally a daily event in our community and has to stop. Too many people are dying or injured, people are not talking about it. And so the conviction rate is not as high as it should be. So this is a message sent to stop, think, and walk away. Your action should be walking away, not firing a bullet. That is a sign of weakness, not strength. So are you asking for restitution? Are there counseling expenses or other damages or injuries that need to be paid for?
We have not looked into it as deep as we have. This situation has caused a strain on the family, although things have occurred that would not have occurred had the situation not happened. Regardless, we are behind Miles 100%. He has reached out to us several occasions saying, I need help, I can't deal with this. Again, with things that go back and forth, we try to reach out and it goes back and forth to where I'm good, I'm okay, I'll figure out a way to deal with it. So being that he's an adult, I guess we really are unsure how to get him the help that he needs. He is not here today.
So are you aware of any counseling or are there hospital bills that you were responsible to pay for? He was?
At that time frame, he did have insurance, so hospitals were paid for. As far as trying to get him counseling, he does not have the resources to pay for that at this time.
Have you all talked to, or has he been referred to community mental health or the crime victims unit for resources available?
Yeah.
Okay, you might want to start there. They can provide a lot of resources. It sounds like he needs it, and there has to be a lot of patience and understanding. He needs to be ready, but he also, many people feel like I can do this myself. It's a sign of weakness if I ask for help, and in fact, it's a sign of strength. But he has to do it in his own time. But he has to know that it's not going to be a financial burden on you or himself. There are resources available, so we can get some help. So, are you in good communication with them?
Oh, yes.
Okay, so perhaps that information can be provided and you can pass it on, and then we do have a unit that works with that. So please let us know. Okay. And I appreciate you being here. Thank you.
Thank you.
Anyone else wish to address the court?
No, thank you, Your Honor. Just a
Thank
few
you.
things.
Have the people.
Your Honor, thank you. Before you today, I don't know if you want to bring the defendant and Mr. Lawson back up to the podium. Thank you, Your Honor. Just briefly, before you today, you have a very young defendant who has committed multiple very serious adult offenses. The court has the very difficult task of balancing the applicable factors of rehabilitation, punishment, protection of community, and deterrence. So I want to take a moment and I want to look at rehabilitation. When I get a mitigation packet or a rehabilitation packet like we did here this morning, and I want to tell the court what the defendant has done so far to demonstrate his willingness, his sincerity to rehabilitate. I received this yesterday from the Ingham County Jail. Excuse me, today I received it Wednesday, February 4th from Deputy Agueros at the Ingham County Jail. She indicates that inmate Anderson has been a real issue while being here. I see that he is on the court list for tomorrow with Judge Aquilina for sentencing. I believe I am attaching 3 incidents reports regarding him. 2 were actual fights with who we believe was rival gang members. The last one was a fight that almost occurred with rival gang members. The report from December 31st, 25, the victim is pressing charges, so he should have pending charges on this one. We are not sure if the prosecutor has made a decision yet. So that's what the defendant has done so far to demonstrate his willingness to rehabilitate to this court. And while we understand that in the Ingham County Jail, these issues can go both ways, it was significant enough, Your Honor, and I've never had this happen before, where the deputy reached out to me to advise me to tell the court this at the time of this young man's sentencing. You know, when we look at punishment, Your Honor, this was a very frightening event. If you recall the trial, it escalated from a group of boys over nothing who brutally beat these young men. I mean, they were going after him, kicking him in the head, kicking him when he was down on the ground. You watch that video time and time again. It was just nauseating to watch, Your Honor. But that wasn't enough. This defendant continued to pursue the victim, and he had a concealed weapon, and he pulled it out and he discharged it. And really, this is a case about inches, because what the doctor told us is that gunshot wound was about an inch away from Mr. Washington's femoral artery in his thigh, Your Honor. And whether you have an intent to kill or an intent to do great bodily harm, if you die from a gunshot wound to your femoral artery, this defendant is standing before us looking at 15 to 25 years in the Michigan Department of Corrections, and we're going to ask for every single day of that. So when we look at punishment, this defendant has already gotten the benefit of the bargain by outstanding counsel and the verdict that he received, and also the luck that Mr. Washington did not die, because he very well could have in this instance. I think the testimony he would have let out in 9 minutes. So we've done our job, Your Honor. We have protected this community by prosecuting this case. We know who this defendant is. This defendant is no secret to the Lansing Police Department or the prosecutor's office. He is someone who drives violent gun crime in this community, as corroborated by his social media account, which shows him in possessions of weapons and semi-automatic weapons and flashing gang signs. We know who this defendant is. We've done our job to protect this community, and now we are asking you, Your Honor, to look at this serious case, his poor efforts towards rehabilitation and the need for punishment and deterrence of others, and sentence him to the maximum sentence possible of 38 months in the Department of Corrections for assault with intent to do great bodily harm consecutive to felony firearm. Thank you.
Thank you. Counsel?
Thank you, Your Honor. Before I begin, I don't think I'm in a position to adequately address whatever issues have or have not been occurring at the jail, since there may be pending charges either currently being issued or under review. I would certainly ask Mr. Anderson to not comment on that, as it could be prejudicial for him. But given that, Your Honor, the limited information we have as it relates to that, I would ask the court to give that little to no weight in its decision regarding sentencing because of that. What I can tell the court, Your Honor, is that Mr. Anderson stands here as a 19-year-old young man. He was 17 years old at the time that these offenses that a jury found him guilty of occurred. He has had no prior charges or criminal convictions of any kind prior to this. The only other matter that he had that we are aware of is he was in the family court for truancy. I think the pre-sentence report details his background, his history, his upbringing, his family structure, along with the package that was submitted to supplement that on his behalf to the court this morning. I think gives the court maybe a better, clearer picture about Mr. Anderson, his life and his upbringing. Certainly, I would ask the court to take into consideration his lack of criminal history up until this point, not to undermine the seriousness of the offenses that he was convicted of, but that certainly is something that the court can and should take into consideration, as well as his age, Your Honor. And I know the court is certainly familiar with the science as it relates to brain development prior to the age of 25, particularly as it relates to cognitive ability. And I don't want my words to be misconstrued on that. I am not saying that that entitles Mr. Anderson to a free pass, or that he does not, or someone at that age doesn't know or appreciate fully what they're doing, because that is not the case. But there is something to be said for that, Your Honor. And I know the court is aware of the science behind that, and I think the legislatures have taken that into consideration as well. With the increase in the eligibility that we have seen for HIDA, it used to cut off at 21, it was increased to 24, and now it is up to, I believe, 26, taking that into consideration. And I think that weighs heavily in Mr. Anderson's favor as it relates to the rehabilitation factor, given his age, given his lack of prior criminal history up until this point. And regardless of whatever sentence the court imposes, I know the court's hands are somewhat tied. It must impose the 2 years for the felony firearm, in addition to whatever time the court gives him on the remaining counts. But the court does have discretion on that. And regardless of whatever sentence the court imposes on that, Mr. Anderson is going to be spending at least a few years in jail, away from the community, away from his family. And I think when weighing into consideration the other factors, such as deterrence to others for the same or similar conduct, protection of the community, and so forth, I think a sentence towards the bottom range of the guidelines would be appropriate. That's what I'm asking the court for, 19 months, which of course would be consecutive to the mandatory 24 years or 24 months that he faces on the felony firearm. I would ask the court not to exceed 24 months on the other counts, because that would be, Mr. Anderson is then looking at 3.5 to 4 years in the Department of Corrections. And that, of course, is just the minimum sentence that he would have to do to get him to the parole force. He's going to have to do well in the MDOC to show them that he is a viable candidate for parole when that time comes. And I'm just asking the court to take all of these factors into consideration and give him a sentence towards the low end of the guideline range. The guideline range turned out to be lower than what was scored, and I have to believe that would impact the Department of Corrections recommendation, as the recommendation they have now currently exceeds the newly scored guidelines. So again, Your Honor, I know the court has to impose the 2 years for the felony firearm, and I'm asking the court for a sentence of 19, not to exceed 24 months consecutive on the remaining counts. Thank you.
Could counsel approach for a moment? Sir, what would you like me to know?
I want to start off by saying, I'm not a violent person. Everybody in this room judging me. I'm not a violent person. My record speaks for itself. I was 17 when this all happened, and I really like to claim my innocence. I was never caught with a firearm. I'm not a gangbanger. I'm a hardworking young man. I had jobs on the house. I don't feel like I'm a threat to the community. I've been trying to get my GED, get on the right path. I just feel like everybody's judging me. They don't really know the real me, so that's all I really gotta say for right now.
Well, sir, you have a lot of very impressive people supporting you, and I hope that when you get out, they're there supporting you and helping you get on the right path. But that evening, I saw the brutality. I saw the film, and you have 12 jurors who found you guilty beyond a reasonable doubt. Taking responsibility, being accountable for your actions is important, and I haven't heard that. I understand you're claiming your innocence. That's an issue for the appellate court. It is not lost on me that while in jail, and I have been a judge over 20 years in this county, I have by now heard thousands of cases because for 4 or 5 years, I had an only criminal docket. It is indeed rare. It's indeed a rare situation where the jail or the sheriff calls me or writes a letter or lets the people know, hey, this person has not done a stellar job while incarceration. That's a problem. That tells me you haven't learned your lesson. That as kind as you may think you are, there's something that's going on that when people around you act a certain way, you are triggered to the point of fighting. The people I have in this red folder who wrote you letters, they are not, to my knowledge, on the list of the sheriff, the violent crimes unit, the prosecutors unit of gang members. They are your community. They are your family. Gang members helped get you here in that jumpsuit before a jury and before this court. Gang members are not your family. They are not your friends. They will continue to get you into trouble if that's the direction you want to go. I know that's not the gang mantra, but that is the reality. And as quickly as we get rid of gangs and we put them in jail or prison, new ones come up. Stay away, sir. Be your own man. When you are part of a gang, they take your voice and they take your choice. Sometimes they take your life or the life of someone you love. Stay away. Have you read these letters?
No.
Have you given him a copy?
I just got them this morning, Your Honor.
Give him this to take with him. He needs to understand that.
I have an extra copy.
Great. He needs to read those in prison. He needs to understand those are his people, not the gangs, not the streets. And when there is a fight, you walk away. You ask for help. You dial 911. You say, officer. And while you may not trust law enforcement, when your loved ones who you will be in prison and not be able to help, while they may need some help and they're dialing 911, guess who shows up? It's law enforcement. They are first responders, safety first. So when they have to attend a party, when they have to break it up, when they have to arrest someone like you, they are not able to save the life of someone you love. Think about that. Stop wasting their time, become law abiding. I have to consider what we call the snow factors, that is punishment of defendant rehabilitation of defendant, deterrence of others, and protection of society, and whether or not the sentence that I impose is proportional. Since we've been here at jury trial, since I've heard that testimony, I've watched the film multiple times. And despite hearing what your loved ones, family members, and friends have said about you, I also have these incidents in jail where you have not been stellar and you have not proven the letters that I've read about you to be completely accurate, sir. Therefore, it is, and believe me, the sentencing guidelines are only recommendations. I could go well above, and in this case, I certainly could choose to do that. Even though there have been corrections and lowered a bit, I could certainly go the higher route. But I'm not gonna do that. As to count 3 and 5, weapons, felony, firearms, those will be concurrent, but those will be consecutive with and preceding any term of imprisonment imposed. So as to the primary offense, you will first serve the 24 months on these two, so they'll be served together, but before any other count. As to count 5, it's the 24 months with credit for 142 days served. And as to count 3, it's the 24 months with credit for 142 days served. Those are served together. And preceding count 4, which is assault with intent to do great bodily harm less than murder by strangulation, where you will serve 38 months to 120 months with 0 credit days served, because you've already received your credit on the counts 3 and 5. And count 4 will be, you'll serve concurrent with count 2, which is 23 months to 60 months. While you are incarcerated, you will receive cognitive behavioral treatment. You will finish your GED and trade school. If there is any additional therapy, such as animal therapy, so you learn the value of human beings, what love really means, and animals love unconditionally, you will receive that treatment as well. You should receive individual and group therapy so you can learn to understand what you did, why you did it, and resolve any kind of anger issues you have. If there's anger management, you should also participate in that. There's a lot going on with you, young man. I don't know what your issues are, because the letters that I have read are inconsistent with what I saw. So I suspect there's a lot of things that people don't know about you because you've kept them to yourself. Am I right about that?
Yes.
Well, you don't have to say yes just because I'm the judge, but I see it, sir. You got some things, you're a quiet kind of person. And there's some things that have gone on that you're unhappy and upset about, you haven't really talked about. The only way to get rid of those is to literally vomit them in front of a therapist, right? You talk about them, you work it out, you understand them, and you overcome them. Everybody makes mistakes. These mistakes are teachable moments. Even these mistakes are pretty huge, but you know what? These are teachable moments in your life. And now comes the fork in the road. When you get done with your time, who do you want to be? What do you want to be? You can accomplish anything you want to. And if you want to be on a path of success, of achievement, of the greatness you were born to, it awaits you. And a whole lot of people will help you there, but they won't do the work for you. You got to do the work. And if you want to go the route of gangs and guns and drugs and violence and partying without any concept of safety, and the prison awaits. There's only 2 forks in the road. I hope you choose the right one. I believe that you'll use this time wisely. And if you want to get out of prison on time, then you must be respectful in prison. Prison will write you tickets. The parole board will look at those tickets. And they will deny the first time you're eligible, and the second and the third time, and you may end up doing all the time unless you behave and you show them you are worthy, you've learned, and these mistakes were simply blips in your life, teachable moments, and you will never do them again. You will be an example and a role model. Is there anything else I need to order in prison that, I mean, I don't run the prison, so I say order, but the warden usually listens to me. So is there anything else I need to order for your benefit?
No, ma'am.
I am going to leave restitution open. It sounds like the victim is having enough anxiety, might need some EMDR therapy, might need some treatment. They have insurance. I don't know if there's co-pays. I don't know what may help them, but I am going to leave restitution open. If they present receipts that you are in disagreement with, counsel, let me know. We'll have a restitution hearing, and that would include restitution by having a transcript of this, especially if he appeals. One will be done anyway, but I think the victim may be able to use that in treatment so the therapist understands what happened. You will pay crime victims assessment, the amount of $130, and estate costs, that's $68 for each count, the amount of $340. That will be payable within 36 months of your release from prison. However, if restitution is being sought, that would be paid while he's in prison, after it's ordered. You have 42 days to appeal and to request appellate counsel. On behalf of the people, are you satisfied? Is there anything you need to make record of?
Just want to make sure I understand the sentences, Your Honor. The 2 felony firearms, 24 months with credit. They will run concurrently with each other and consecutive to the other charges.
Yes.
On the assault, GBH, 38 to 120 months, Your Honor.
Yes.
On the felonious assault, I didn't catch the sentence, please, on the felonious assault.
On the felonious assault, let me just get that. That is. Oh, sorry, that is 17 months to 48 months. And again, 0 credit.
Right, and on carrying a concealed weapon, the only reason I ask is I think the CCW has to, I think you're gonna get something from the Department of Corrections, the CCW has to run concurrently with the felony firearms because it's not a predicate felony. So whatever the sentence is on CCW, I just want you to amend that to concurrent to the felony firearms.
All right, concurrent to the felony firearms.
Thank you very much. People are satisfied, Your Honor.
Yeah, it was written in sort of a weird order, so thank you for that. Anything else?
No, Your Honor, thank you.
You have 42 days to appeal and to request appellate counsel. Do you have this?
I just gave him the form, Your Honor. He took receipt of it.
All right, so sir, if you're unhappy with this for any reason, it's your absolute right to have an automatic appeal, but you need to fill that out within 42 days, requesting an appeal with appellate counsel. Do you understand?
Yes, ma'am.
Any questions?
No, ma'am.
Thank you, that is all for the record.
Thank you, Judge.
Jordan Wormness.
Sorry?
Jordan Wormness.
I don't think that's there. She's over.
Just saw her, I just told
She's
her.
over in Judge Stokes' room. We have a set aside we could do.
Yeah, we can do the set aside.
Or break, yeah, or break.
And then we'll need a break. Yes, definitely need a break.
I'm just concerned, Your Honor, because Wormness is at MDOC, and I don't know if they may kick him.
Well, we just need to get her, where is she?
She's in Judge Stokes' courtroom right now.
Well, that could be a while,
So we'll
She has
move forward
3.
with Jonathan Kelly.
She has 3 hearings in Judge Stokes' courtroom right now.
They're behind as well.
Is Mr. Kelly here? Mr. Kelly? Yeah. Okay, please.
Do you have counsel or are you representing yourself?
He's coming.
Mayor, sorry.
All right, this is docket 1686FH, People of the State of Michigan versus Jonathan Kelly.
Good morning or good afternoon, Your Honor. Timothy Williams on behalf of Jonathan.
Counsel?
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. On behalf of the people, have you reviewed this file and are the people in objection or agreement? And have you received the requisite information from the state police and the attorney general?
Your Honor, we have received the letter from the Attorney General that says the defendant may be eligible if the court determines the post-conviction circumstances and behavior warrant the setting aside. Therefore, the people leave it in the court's discretion. Thank you.
Counsel, what would you like me to know?
Thank you. Your Honor, this particular offense obviously happened in 2016, excuse my voice. Jonathan's last conviction of any kind was in 2021. It was a misdemeanor, I think, MDOP under 200. He's grown a lot since then. I've known Jonathan. I represented Jonathan on the original charge in front of Judge Collette. And yes, if you look at his criminal record, a lot of misdemeanor, a lot of traffic misdemeanors, bit of a hellion in his youth, but he's really mature. He's in a stable relationship now. He's going to college at LCC. He's doing DoorDash for income, living with his mother. His mother's here today. She indicates, I mean, she's been through him through thick and thin. Everybody deserves a mother as supportive as her that she has been of Jonathan. She's been a rock for him. But she reports that he's behaving himself. He's respectful. That's why she continues to allow him to live in her home, and that he's made a dramatic change. Frankly, she's the one that paid for me to be here today. And again, I've known her a long time. And if she wasn't convinced Jonathan had turned the corner, I wouldn't be here. Thank you.
Thank you. Sir, what have you learned from this?
I've learned that I need to take care of my mental health more. At the time, I wasn't taking care of it at all. I wasn't seeing a counselor or anything. Now I'm seeing 2 counselors. One's an EMDR therapist, and I'm also seeing a psychiatrist at CMH. So keeping my mental health in check is very important.
And are you working? What are you doing?
Yes, I'm working. I do DoorDash right now.
And what are you going to school for?
Social work.
Oh, good. Some of the best social workers have gone through all this.
Yeah.
All right. Thank you. An application is set aside. The following conviction was filed on January 20th. And there's a typo here. I'm just going to handwrite it in white out that it was filed January 27th, 2026. Is that correct?
No, it had been filed before that.
Okay, well.
That's the receipt stamp set on my file.
Do you know when it was filed? Because it says spring 27, January 22 plus 6, which makes no sense. Any idea when it was filed?
I believe it was filed sometime in November, for sure, I think it was 11/25. when I served all the parties.
We're gonna look it up. All right,
Sorry, I didn't have it.
it's okay.
Thank you.
This one I have to receive stamps. All those we put into.
The conviction was for home invasion, second degree. And the date of the conviction was November 23rd, 2016. The Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault or crime set aside pursuant to the statute during their lifetime, and there are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant has not previously had a felony conviction for the same offense set aside pursuant to the statute. The time period required by the statute for the conviction listed in item 1 has passed, and an opportunity has been given to the prosecuting official, attorney general, and state police to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Do we have a date?
December 3rd, 2025. Yeah, I'm.
Looks like the application is set aside, was filed on or about December 3rd, 2025. The application is granted as to the conviction listed in item 1 and pursuant to the statute. The Michigan State Police shall maintain a non-public record of this order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in each case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Sir, please approach.
Yes. Thank you.
Congratulations.
Thank you.
Go back to the podium 1 more minute. So once you leave this courtroom, this court no longer has jurisdiction over you. So my last order is that you take your mother and any other loved ones out to dinner for a celebration.
Okay.
Can you do that?
We will do that.
All right, congratulations. That's all for the record.
Thank
Do you have a copy?
I have 2 more.
That's all for this record. We need to take a break unless we're ready on the Department of Corrections. We will be back shortly. I gotta give the court reporter a break. It's been a heck of a week.
All rise.